All right, good morning, everyone. I'm going to call to order the Code Enforcement Magistrate hearing from Martin County. Today is the 20th of March already. If you'll please stand, join me in the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, please be seated. A crowd this morning, which is a little unusual for us, but so I'm going to try and take cases, if not in the order that you appear, at least we'll try and make sure that if you're here, we're going to take you first. So the first case that I've got in front of me is case number GMD 2022-10315. Martin County is the petitioner versus High Order Maritime, Inc. Anybody here in, Mr. Wright, here for Maritime, High Order Maritime?
Yes, good morning.
Good morning. All right, so this is a violation case. We're going to hear from the county first. If they make a prima facie case, then I'll flip it over to you, and then you can ask questions. You can.
Mr. Magistrate, I have a motion to suppress evidence that I served on the county this morning. I have a physical copy for you.
Okay.
I spoke to Ms. Elder, who agreed that we should consider that first.
All right. Ms. Elder is here on behalf of the county?
Yes, Your Honor.
Okay, very good. Let's see what we've got. Thank you.
No. I just have it on my iPad. Sorry.
Okay, Mr. Wright, we've got a couple things to deal with here. First off, just let me ask you, the case in the 19th Judicial Circuit, has that been filed,
Yes, Your Honor,
and has it been served yet?
it has.
Okay, so the copy that I've got doesn't have a case number, Judge, but I see that you entered a case number in your pleading for this morning.
Yes, there is a pending action that was served on the county, I believe, yesterday.
All right,
It was.
okay, and did you accepted service?
I actually accepted service myself.
All right, fine. Let me just ask, I'm sorry, I don't have a pen, and I'm going to need one, I think, this morning. Unusual, but thank you. All right. All right, go ahead and argue your motion, if you will, Mr. Wright.
So, Your Honor, the county has been making helicopter passes over my client's property and doing surveillance and inspections without ever attempting to or obtaining an inspection warrant as required by Section 933.20 Florida statutes, which specifically requires an order in writing in the name of the people signed by a person competent to issue search warrants pursuant to 933.01 and directed to a state or local official commanding him or her to conduct an inspection required or authorized by state or local law. And then it goes on relating to any, and I'll just, land use or zoning standards. And so the county code enforcement department has been regularly riding along with sheriff's helicopters to look at properties and to obtain evidence with a warrantless search. And the gravamen of our motion is that any and all evidence that they have obtained by virtue of these illegal searches cannot be used as any grounds for this code enforcement board action. My client happened to be on his property on August 29th, 2023, and observed a sheriff's helicopter passing over and circling his property, and snapped a photo of it. And the next day received a call from Mr. Mitchell saying, you know, you've got code enforcement issues going on your property. And my client said, what were you doing flying over my property? And he apologized, said, you know, if I broke the law, I'm sorry, but, you know, we think you're doing X, Y, and Z on the property, all as a result of this helicopter flight over my client's property that was done without a warrant. And so we request that you exclude any evidence that is fruit of that poisonous tree or the prior warrantless searches by helicopter that were done either before or after August 29th, 2023.
Okay. To your knowledge, has the county done this since that time?
I do not know whether or not there's been any subsequent helicopter flights over the property since that time, but I'm happy to call Mr. Mitchell to the stand and lay out an evidentiary basis for that.
All right. Let me just ask the question. Mr. Mitchell, I'm going to need to swear you in.
Yes,
And do you swear or affirm testimony about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right. I didn't answer my simple question. Since 29 August 2023, have you participated in overflights of this property?
No, that was it.
Okay. All right. County, do you have anything further, Mr. Russ?
Nothing, we'll stand on the motion, Your Honor.
All right.
Good morning, Your Honor. Elise Elder, Deputy County Attorney on behalf of Martin County. The United States Supreme Court has addressed this issue in Florida versus Riley, where they overturned the Florida Supreme Court and held that observations in a residential backyard from the vantage point of a helicopter circling 400 feet or above do not constitute a search requiring a warrant. So it's the county's position that Mr. Mitchell can testify that he was well above 400 feet. It's the county's position that we don't need a warrant for that because there's no, as the United States Supreme Court held, and I'll give you that site, Your Honor, and I have a case for you as well. It's 109 SCT 693. The Supreme Court of the United States held that there is no expectation of privacy from the air in your backyard, and as a result, it does not require a warrant. I have a case for you, Tim.
All right, I would tell you that it's not unusual to have evidence presented here that consists of overflights of private property. Thank you. And I don't know,
I'd like to respond to her argument on the Riley case, because the Riley case is a criminal case. In Riley, it was not a code enforcement board action, and this section of the statute that we're relying on, 933, absolutely requires that the government obtain a warrant in order to conduct an inspection required or authorized by state or local law relating to any municipal or county building, land use, or zoning standards. And so when the statute requires an inspection warrant, in order to do an inspection, this statute goes above and beyond a criminal investigation of a police officer just randomly flying over property observing something. We believe that in this case, Mr. Mitchell and the Sheriff's Department, when they took off in this helicopter, were doing so specifically to go inspect this property with the helicopter. We filed a lawsuit alleging that, and we believe that they'll concede that that's exactly what they were doing. And so when they made this inspection without a warrant, they violated the law, and all of the evidence that they obtain as a result of that flight and any others is legally impermissible in this hearing.
I can tell you how I have construed that prior to this time, and essentially it is that if it's inside a building, inside a structure, then absolutely 933 comes into play. No question about that. But if it's just viewing the property from the air, the county has done that many, many times based upon, I guess, the Riley ruling. And I know that in the past, again, my understanding of it is that that Riley did apply. Now, there's maybe more to it than that, but at least initially, that's my understanding of the law. And I'm willing to look at more if you want to provide more, particularly on 933, if you've got a case specific to code enforcement or...
Well, I do have a Attorney General opinion that you may be aware of. It's AGO 2009-37 that specifically held that a local governing code enforcement board cannot, without a property owner's consent, conduct a search. And if your determination is that flying over with a helicopter to take photographs and obtain evidence by the code enforcement board officer of supposed code enforcement violations doesn't constitute a search, we understand your ruling.
If I may respond, Your Honor? I think this AGO talks about entering a premises. It's no different from standing on the sidewalk and taking pictures of a violation. The county is entitled, just like you said, to go in the air. The statute that Mr. Wright references has to do with entering premises and getting a warrant when a warrant is required. A warrant is not required for the county to fly over someone's property.
Yeah, I think it goes back to kind of that old common law principle of breaking the close and whether you're actually doing that. And so I know historically, code enforcement officers will not go past a fence. They won't go violate that part of a person's property physically if they're in and see, and even if they observe a violation, they're not going to step onto that person's property if it says no trespassing. There are a lot of things that guide how code enforcement officers do their work, but if they're on public right-of-way and observe a violation, that's fair game. And my understanding is that if they're in a boat and on public waters and they observe a violation, that's fair game. And also, since I guess 1989, if they're in the air and they observe a violation, that's fair game. So I think that's where I'm going to come down on this, unless you've got something else.
The only thing else I have, Your Honor, is not directly applicable, is the Florida legislature recently adopted, and I'm sorry I don't have a copy for you. It's Section 934.50 regarding searches and seizures using a drone.
Right.
And admittedly, this was not a drone because it was carrying human occupants, but it specifically provides that it's prohibited for a law enforcement agency to use a drone to gather evidence. And so I'd respectfully suggest that if you can't go fly a drone over someone's property to gain evidence, then the Florida legislature has made a clear indication that if you can't use a drone, why would you possibly be entitled to take a helicopter and do the exact same thing? And so we suggest that Florida Statute 934.50 is at least an indication of Florida's view on the subject.
Would you like me to respond, Your Honor? We are aware of 9.3450, which is why we do not use drones to inspect properties. That is a completely different mechanism than an individual flying over. We acknowledge this statute. A supposed intent by the Florida legislator to overrule a Florida Supreme Court case is a stretch. A United States Supreme Court case is a stretch. The Supreme Court ruled on this specific issue, and there's no other law that supersedes it, including this drone statute, which has no relevance on what Mr. Mitchell did in this case.
Okay, I don't have 934.5 and in front of me. However, having said that, I presume that the legislature knew what they were doing when they said drones and not drones and helicopters and any aerial device. So I think that's where it stands. So I'm gonna deny your motion.
All right?
And let me just ask you, in your complaint in the 19th Circuit, did you also argue any of that? Because I'd be really interested.
We've specifically alleged a violation of the statute and are seeking damages and all other appropriate relief as a result of what we consider to be an illegal search without an inspection warrant.
I think we're all going to be very interested to see how the court deals with this, because, I mean, you raise an interesting point. It's pretty novel, and it would be a turn of events, I think, in Florida if you're successful. So, okay, all right. Are we ready to proceed with the case?
County's ready, Your Honor.
All right. Mr. Wright, you ready?
Yes, Your Honor.
Okay, good. Let's take the case then of Martin County versus High Order Maritime, Inc. It is a violation case, and I've sworn in the county's witnesses, Mr.
We have other witnesses, Your Honor, that might
Oh,
need
you
to be
do?
sworn in. Yes.
Okay. All right, well, I'll just, as you bring them up, I'll swear them in. Okay, let me just grab one thing here. All right, let's see. Mr. Mitchell, whenever you're ready.
Yes, sir. My name is Jerry Mitchell. I've been sworn in. I am a senior site compliance officer for Martin County. The respondent, High Order Maritime, Inc., is present. Ryan Helmig, the owner of High Order Maritime, is present, as well as his attorneys, Tim Wright, are here as well on behalf of the respondent. This case concerns the unassigned property located in Stewart, Martin County, Florida. In this case, was not generated from an anonymous complaint. According to the official records of the property appraisers of Martin County, the property owner is High Order Maritime. A copy of the property appraiser's record of ownership is going to be County Exhibit 1. Aerial view of the subject property is provided on this 2022 aerial and is marked as County Exhibit 2. Subject property is outlined in blue here. I'm highlighting the 7290 address because he owns that property, or High Order Maritime is also the owner of that property as well. But we are here today specifically for the subject property. A little bit of land use information on the property before I proceed. The future land use designation for the property is low-density residential. The county's future land use map identifying the property as low density is going to be marked as County Exhibit 3. The current zoning designation for the property is B1 Business District. The county's zoning district map identifying the property as B1 is going to be marked as County Exhibit 4.
Okay.
Additional background information before I proceed. Ryan Helmig is the owner-operator of Cito Business and Services, Martin County. On July 12, 2022, Mr. Helmig purchased the property and shortly thereafter commenced using the property for the Cito business operation. On October 21st, 2022, I inspected the property. At that time, I observed the storing, parking, and keeping of boats and trailers, fuel tanks, turbidity curtains, and other miscellaneous items on the property, as well as there were some inoperable boats and trash and debris. At that time, I photographed the property. The photographs accurately show what I saw then are going to be marked as County Exhibits 5 through 8. So here I am walking along Cantor Highway and taking a picture that is showing the inoperable boat in that picture and other boats. Here I'm showing,
You're now on Exhibit 6?
I'm on these, yes, Exhibit 6. Here, I'm just pointing out the boat trailers and the items on the property, as well as this is kind of looking like a trash heap back here. Exhibit 7, what I'm showing in this picture is among the sea-doos and the boats and stuff. Back in the background here, you can see some fuel tanks and then miscellaneous items over here to the right. And Exhibit 8 is, again, showing the vessels here, but also this is a boat that appears to be on the ground. There's also a turbidity curtain there. Also, on November 29th, 2022, I performed an aerial inspection of the property. At that time, I photographed the property. The photographs actually show what I saw then. They're going to be marked as Exhibits 9, 10, and 11. So 9, I'm just kind of showing, this was the boat I took and you show exhibit that I showed there and just showing the items on the property.
That's the one in Exhibit,
That was the one in Exhibit 5. That's that boat there. Exhibit 10, and again, this is an overview of it, and here's some, you see some trailers on here. Now, I just want to show this entrance where the house is. Everything that's to the right of this driveway you see here is going to be the property that we're in question today. So anything you see left pretty much of this road here is going to be not in today's hearing. It's just everything to the right of it. Exhibit 11 is just, it's a view from the, kind of the back side of it, just showing, you can see the store, let me blow that up a little bit. You can see here, there's, sorry. This is where you can see the storage containers. You see a tractor here, and you can see the boats on the property right here. And those were exhibits 9, 10, and 11.
all right, the boats that, that are in Exhibit 11, where your cursor is, are they on a hard stand, or are they just
These-
parked in the sand? or-
These are on the ground, dirt. Yes, sir.
Okay. All right.
Based upon that investigation, I did issue a notice of violation to High Order Maritime on December 7th, 2022, marked as County Exhibit 12. In that notice, I cited the following Martin County Code violations. Excuse me. Section 3.201A, accessory uses and structures, land development regulations, Martin County Code. Section 91.34A, generally inoperable vehicles, general ordinance, Martin County Code. And Section 67.201B, nuisance declared, general ordinance, Martin County Code. Just for the record, Section 91.34, generally inoperable, and Section 67.201B is no longer an issue. In the notice of violation, the respondent was given 63 days to correct the violation and was informed to contact the code enforcement upon doing so. On December 14, 2022, Attorney Tyson Waters informed me that he would be assisting the respondent in this case, that he is reviewing the matter and would be in touch to set up a meeting to discuss once he had more information about the situation. It was suggested that he schedule a pre-application meeting with the development review team because the use is not consistent with the future land use and there is no development order authorizing the current use on the property. On May 11th, 2023, a pre-application meeting was held with Attorney Tyson Water and professional land planner Michael McCarty, and they were advised to apply for a land use amendment and zoning change and to receive a site plan approval. As of the date of this hearing, an application has not been submitted. On August 29, 2023, I performed a subsequent aerial inspection of the property. At that time, I observed that additional commercial equipment, fuel tanks, and the construction of an aluminum structure placed atop of a set of storage containers were added to the property since the initial inspection. At that time, I photographed the property. The photographs actually show what I saw then are going to be marked as county exhibits 13, 14, and 15. So 13, what I'm pointing out here is the storage containers with the aluminum structure rooftop there. I'm pointing out the lift or the crane, the red crane you see here. And also you see behind, in front of those cranes, you can see some fuel tanks. I can screw this around. The fuel tanks here. 14 is more of the same picture, and you just see a better picture of the aluminum top of the storage containers. And 15 is, what I'm pointing out here mainly, other than the boats around the property, is there's a big crane on the property right here. It's kind of hard to see, but it's definitely there.
Okay, I see it.
Based upon the additional items placed on the property, on October 10th, 2023, I issued an amended notice of violation and notice of hearing by certified mail to the respondent with a hearing date scheduled for January 17th, 2024. The amended notice of violation, notice of hearing issued then is going to be marked as County Exhibit 16. In the amended notice of violation, notice of hearing, I cited the following Martin County codes: 3.201A, accessory uses and structures, land development regulations, Martin County Code, Section 105.1, Florida Building Code, required as incorporated by Section 21.1 General Ordinance, Martin County Code. In the amended notice of violation and notice of hearing, the respondent was given till January 12, 2024 to correct the violations. Violation 1 and violation 2. I'll proceed when you're ready.
Go ahead.
You ready? Okay. The return receipt was received on October 16, 2023, and is marked as County Exhibit 17, so we had good service. The matter was continued twice, once at the request of the respondent and once at the request of the county. An amended notice of violation and notice of hearing was issued to the respondent by certified mail on February 27, 2024, with a hearing date scheduled for March 20, 2024. The amended notice of violation and notice of hearing issued is marked as County Exhibit 18. Oops. In the amended notice of violation, notice of hearing, the following section codes were cited. Comprehensive Growth Management Plan, Martin County Code, Policy 4.9H.1, Protect Residential from Commercial Uses, Policy 4.13A.73, Low-Density Residential Development, Policy 4.13A.7, Residential Development. Also, Section 10.1C, Development Order Required, and Section 3.201A, Accessory Uses and Structures, Land Development Regulations, Martin County Code, and Section 1.105.1, Florida Building Code, required and incorporated by Section 21.1 General Ordinance, Martin County Code. And that's cited for the aluminum structure, the storage containers, and also the fuel tanks is why we cited the Florida Building Code. In the amended notice violation, the respondent was given until March 15 to correct the violations. The return receipt was received on March 5th, 2024, and as marked as County Exhibit 19. Just like to show an updated bird's eye view of the subject property is provided on this 2023 aerial and is marked as County Exhibit 20. And basically showing the outline of the property there. The property lines are not exact. As you can see, it's going over the roof of the house there. But we're looking at everything above the house there. And I wanted to show that you can see the canopy structure here. You see the lift or crane here in that picture. And here's the other crane over here on that side.
All right, and what's the source of Exhibit A, 20?
This is through the property appraiser's website. They have a bird's eye view layer that you can click on and use, and it shows that this picture was, according to their website, on November 30th, 2023. This is a bird's eye view of the property.
And do we know the date of the photo?
As far as I know, they're saying that as in the top left hand, you see where it says 11/30/2023. So I'm under the impression that's the date.
Okay. All right.
Okay, I'm gonna, my next three exhibits are gonna be outside of this Legistar system, so I'm gonna have to go to the T-Drive to present them. But on March 19th, 2024, I re-inspected the property, so yesterday afternoon. I saw that cited violations had not been corrected. At that time, I photographed the property. The photographs actually show what I saw then are marked as County Exhibits 21, 22, and 23. The reason why they're not in Legistar is because I took the pictures later than when it was ran, so I have to go out here. So, Exhibit 21, I'm on Cove Road, and I'm off the side of the road there. You can see the boats in the picture there. I'm sorry, Canner Highway, on Canner Highway. That's Exhibit 21. Exhibit 22 is another shot. I was just, again, I'm on Canner Highway, just driving along the curb, or the sidewalk, basically. You can see the boat here. You can see the yellow, looks like to be Tibeti curtains. There's another boat here. The cell in the background is probably in the water, so that's not what's part of this picture. What I'm basically showing is the boat right along the fence here. And I will note it is screened. we can still see what's going on there. And finally, the last one is going to be Exhibit 23. This is, I just got a pretty good shot of the crane here, and actually, at the time I was there was some activity or operator on this Kubota tractor at the time. Not 100% sure what was going on at that time, but anyway, yeah, just wanted to say you can see it from the road. I request that all the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent, High Order Maritime, be ordered to comply with the cited provisions of the Martin County Code by April 22nd, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 per violation per day thereafter for every day the violations continue thereafter. The county has incurred a cost in the amount of $575 in conducting this investigation and requests that this amount be reimbursed to the county at the conclusion of today's hearing. And at this time, this concludes my testimony.
Your Honor, I would move to strike all of the testimony and object to the introduction of any of the evidence based on relevance, hearsay, and again, as fruit of the poison tree as laid out in our motion to suppress.
All right.
Your Honor, based on our last argument in the motion to exclude the evidence, the county would say all of this evidence was obtained properly. Mr. Mitchell obtained it from county right-of-way from more than 400 feet above the air, and he can testify to the how far he was up in the helicopter. It's all proper evidence that is provided to you today. We would ask for you to admit it into evidence this morning.
Okay. Your objections regarding relevance?
Well, he's gone on, it was a long narrative answer, and so he went through the previous violations that are not the subject, or the alleged violations that are not the subject of today. He's gone through a bunch of testimony about discussions that were had with Mr. Tyson Waters about permit applications, and so there's a lot of things that he said that aren't relevant to the 3 violations that they allegedly are bringing today.
I think I followed him through all of that well enough to understand it. So I'm going to go ahead and deny your motion.
I do have cross.
Yes, go ahead, please.
All right. So let's start with the amended notice of violation, sir, which I believe is maybe 18?
18.
Yes, sir.
Okay, so the first violation you're alleging is a violation of the Comprehensive Growth Management Plan?
That is correct.
And do you claim that there is some provision in the Martin County Code that gives the code enforcement department authority or a remedy for alleged violations of the comprehensive plan?
To the best of my knowledge, that's correct.
Well, can you cite to the magistrate a provision of the code that says any alleged violation of the comprehensive plan can be the subject of a code enforcement board action?
I don't have an answer for that question.
And so you agree that at the time that the county adopted the comprehensive plan in the 1980s, at that time, my client or his predecessors already had the B1 zoning district as its zoning assignment, correct, sir?
I know it's zoned today as B1. When it was done, whether it was the 80s or before, I don't know that answer.
And if you would, sir, pull up, could you please scroll up in your list of exhibits? Let's take a look at the future land use exhibit 3. And if you'll scroll back out, you see that the property that is to the, I'm sorry, I thought it would show. You can see that the property that's to the west and the east of this property both have commercial waterfront land use designations.
Yes, I can see that, yes.
And you're aware that it was the county that established or assigned low-density residential to this property, despite the fact that it was a business zoning district at the time of the adoption of the plan, correct?
I don't know that for a fact. I can't answer that.
Okay. But you're aware that, in fact, there are commercial waterfront uses on both sides of my client's property, correct?
I'm going to object to relevance.
On what basis, though?
We're here on his client's property that has its own future land use and its own zoning, and that's what's relevant here today. Another property that might be zoned a different way has no bearing on this case.
Yeah, I'm going to sustain that.
Okay.
I'm-
So,
Go ahead.
did you include, so next, let's take a look at, what is the zoning designation of the adjacent properties, sir?
Well, the adjacent one, here it shows R2, if you're looking at this one.
Well, the actual adjacent one to what I'm calling the west is B1, the same.
Oh, okay, they're up here. Okay, B1, yes.
So the western property has a B1 zoning district and in fact is a commercial use, correct, sir?
This is zone B1, yes, sir.
And what is the zoning of the property to what I'm calling the east or north?
This property here would be, that I have highlighted in blue is B1.
That's my client's property.
Yes,
But the one to the north and east of that, what is the zoning?
right here?
I'm going to object again to relevance.
Yeah, I'm sorry, Mr. Wright, I fail to see what the relevance would be here because each parcel of property has its own discrete zoning category, and what's on one property may not be on an adjacent property.
I'm trying to establish that they're treating my client differently, that the neighbor to the south has B1 zoning, the exact same zoning that we have, is permitted to do these things, and they're bringing this violation. It's an equal protection.
Okay, but there's a whole host of reasons why that might occur. If the neighbor has a development order that allows for it, if they got a zoning change or some sort of variance or,
I'm just establishing that the owner, I just would like to establish evidentiary-wise that the owner to the south has the same zoning category and is conducting a similar use.
go ahead.
And the fact that they may differentiate and say that they've got other
ahead, ask
options
your
is
question.
their prerogative. Okay. Let's bring up, I think it's is Exhibit 4 just the map?
That's it's the exhibit 4 is up.
Okay, and do you have an exhibit that we can put on the screen with the actual provision of the statute, the section 3-417 business district?
So he wants to pull up the Muni code?
Yeah, we don't have an exhibit with Municode.
We don't have it, no, sir.
So I would move into evidence as respondents Exhibit 1, the B1 business district provisions. You're familiar with those, correct, sir?
I've seen this before, yes.
okay, I'm going to mark this as Exhibit 1, Respondents 1. And let's see where you go, and then you can move it in.
Okay. So you agree that the subject site and the immediately adjacent site, also owned by High Order, have the B1 Business District zoning designation, correct, sir?
Yes,
And you agree that one of the permitted uses in the B1 Business District is refuse and storage areas which shall be screened from view. Do you see that?
number 6, I see that, yes, sir.
And you concede that the refuge and storage areas have been screened from view, correct?
I see that they did put screen on them, yes.
Okay. Both over the top visually and on the road, correct?
The screening from the road is on the fence itself.
Okay.
I'm not sure what you mean over the top, but.
Well, you showed the magistrate an aerial view of a cover covering some of the materials that were being stored on the site, correct?
That is correct, it's on there.
And you don't have any personal knowledge that any of those, that the screening over the storage materials is an actual structure attached to the land, do you, sir?
Are you referring to Exhibit 14, if you will? Just bring that up. Is that what we're talking about?
Yes, sir, the green,
Okay.
you can see from that photograph that is a tarp that is not actually attached to the land, it's just sitting on the storage containers, correct, sir?
That is the structure on top of there. Whether it's a tarp or it's aluminum, I don't know that, but it is sitting on top of storage containers.
Okay.
Plainly.
It's not attached to the land, and the storage containers are not attached to the land, to your knowledge, correct, sir?
Far as I can see, they're just sitting there, yes, sir.
They're just sitting there, right?
Yes.
So they can be moved?
I'm sure they can be moved.
Okay. And I'll also, so I would move Exhibit 1 into evidence.
Downey, any objection?
No objection.
With no objection, it's so ordered. And incidentally, let me just clean up the other part of that. I did not formally say that Exhibits 1 through 23 I'm accepting on the county side. They've moved them. You objected, I ruled, and so they're in.
Next, I'm going to show you, and I'm sorry, for some reason I only have 3 copies, Section 559.99, I'm sorry, 559.955. You're familiar with this provision of the statutes, correct, sir?
A little bit, yes, sir.
Okay. And it provides that a local government may not enact or enforce any ordinance, regulation, or policy or take any action to license or otherwise regulate a home-based business in violation of this section, correct?
That's for a home-based business, yes, sir.
And you're aware that, in fact, my client has a home on the property and is living in it and running his business from that home, right?
I know there's a home on the property. He claims someone's living in it, whether it's him or somebody, I don't know that answer, but that's on the subject, that's not on the subject property we're talking about today, though.
Well, that's on the immediately adjacent property, which you conveniently excluded from the notice of violation, correct?
I went after the vacant lot, not
Okay,
the.
but you're aware that it's the immediately adjacent property, the home that we're looking at in the photograph is in fact my client's home. That's his truck parked in the driveway, correct?
If you say so, yes. Sir.
If we're still looking at Exhibit 14, is that correct?
Yes.
And the truck that you're referring to, which one is that?
The black truck immediately, right up against the home?
Okay, let me get.
I personally don't know that,
Okay.
no.
Okay. Well, you don't know what businesses, if any, are actually being conducted from that home, do you, sir?
I'm not aware of any.
Okay. But you're claiming that my client, as part of this code enforcement hearing, is illegally conducting a business on this property without a proper permit?
What we're saying is that that is a vacant lot for the subject property, and that under our section code, he has developed the property, and he does not have a permit to do so.
Okay. And the provision of the statute expressly provides that a home-based business, assuming it's a home-based business, assuming that either High Order or CETO is operating from that home, it's operating in an area, is it zoned for residential use?
The current zoning on is B1. The future land use is low-density residential.
Okay, and that's what the county designated this property as, both properties, both the house and the vacant, what you're saying is a vacant lot next door, has been designated by the county as B1 and low-density residential.
That's what we have as a record, yes.
And you agree that the county gave a designation in its land use that's, you claim, inconsistent with the B1 zoning, correct?
It's inconsistent with the future land use. That's why it has to, that's why it requires a zoning change and amendment to the zoning district, and also would require a site
Well,
plan.
you agree that nothing in Exhibit 1 requires, in order to be allowed to use the land for refuge and storage areas, some land use change, right?
They would, I'm sorry, repeat that, please.
You agree that my client is entitled, under their current zoning, to use the property as refuge and storage areas, correct?
With an approved site plan,
Well, it doesn't say anywhere with an approved site plan in this provision, does it, sir?
and that, what you're showing me, no.
And so your theory is, if my client and his predecessors have been using this property, storing boats on the property for 20-plus years, that continuing to store boats is some violation of the code?
I'm saying storing anything on that property on a vacant lot is in violation of the code.
Even though you agree that the B1 zoning district permits that use?
B1 zoning district would permit that use, but I was going to say, before, you got to have an approved primary or principal use on the property.
You haven't cited anywhere on your notice of violation that legal theory, correct, sir?
I'm not sure what you're talking about, I'm sorry.
Okay, well, let's move on. So, you believe, what evidence, if any, do you have as to whether or not my client is conducting a home-based business on the property or the adjacent property at his home?
My understanding is he's running a CETO operation off the vacant lot,
Okay, and where did that understanding come from, sir?
from him himself,
Okay,
Mr. Haley.
okay, and
I
so,
think he doesn't deny the fact that he's running a CETO business off
so
there.
it's your belief that he in fact is running a home-based business on the property, correct?
I'm saying he's running an operation on the vacant lot without an approved development order or site plan.
Well, let's take a look at your previous notice of violation, which I believe is Exhibit 12. And in that violation, you cited on the first page to 3.201 subsection A. Do you see that?
Yes.
And that's part of what you're claiming for the current violation that we're here on today, correct, sir?
Yes, that's same as,
And it specifically provides in 3.201A that accessory uses and structures are permitted in any zoning district when the uses or structures are number 1, 2, and 3. You see the subject, the categories?
yes, sir, I see him.
So you don't know one way or the other as to whether or not the storage and refuse uses on the vacant lot are ancillary or in connection with or incidental to the principal use or structure on the district, do you, sir?
What I understand is, I guess the answer is no.
So if my client testifies that those uses are part of the business that I carry on out of my home on that property, you have no basis to dispute that, do you, sir?
Objection, calls for a legal conclusion.
Actually, that's part of his job, is to decide what violates the law and doesn't. Go ahead and answer the question.
Just repeat that question, please.
Okay. Well, first, why don't we skip to an easier one, 3? You agree that the house and the lot that the house is on is contiguous with the lot that you're claiming is in violation of the code, correct, sir?
That is correct.
And you claim that you don't know whether or not the principal use that's going on in the house is, well, you do know that both lots are under the same ownership, correct?
I do know that, yes.
And they're in the same zoning district, right?
Yes,
So the house and the vacant lot both have B1.
currently, yes.
And the house may or may not be being used as a CETO business for which the activities are going on in the vacant lot. You don't know one way or the other, correct?
I'm not 100% sure what actually is all going on there. All I know is he had mentioned he's running his CETO operations off the property.
Okay. And you don't have any basis to dispute that, right?
No, that's what I think we're here.
Okay.
Yeah.
So that, the CETO business that's being operated out of his house with the B1 zoning district is what's going on the property, right?
He's utilizing both parcels for his CETO business.
Okay. So, assuming that it's a CETO business and assuming that the CETO business is being used in connection with the structure on the adjacent property, and assuming that these uses are going on the contiguous property, then there's no violation of 3.201, correct?
My understanding, it is a violation.
Well, if we assume that there is a CETO business and the CETO business is using the adjacent property for storage and refuse, then it's ancillary or connection with or incidental to the principal use of the structure, right?
It's a commercial activity.
Okay, and it's being done out of a home, correct?
Where the home is, the operation is being ran out of the home.
Either it's an office and someone's living there, or it's a home and someone's conducting a business out of it, right?
Correct.
Do you know which it is?
By my understanding, it's both.
Okay, so it's both a home and an office, right?
What's going on the property, yes.
Okay. And so if we look at your violation number 3, you're claiming that, that since there's no principal use, I'm sorry, if we could go to the next page, sir.
Oh, violation,
Wait, I'm sorry, I was looking at let's go to the current notice of violation.
Exhibit 18.
Yes.
We're still back on violation 1,
Now we're on 18, Exhibit 18,
exhibit 18, okay.
second page, violation number 3.
So this is the actual notice of violation that we're working with.
Yes, yes, Your Honor. Violation 3, you're alleging that there's no principal use or structure on the property because you just conveniently excluded the entire, both parcels which were purchased at the same time, right?
The vacant lot is, there's no principal structure on the vacant lot.
But there is a principal use or structure on the contiguous lot, correct?
Yes.
And then in 4, you're claiming that there are aluminum structures or storage containers or fuel tanks on the property, right?
Yes, that was,
And you don't know one way or the other whether those tanks are empty and clean or whether they have fuel in them, correct?
I do not know that, no.
Okay, so if they're just empty tanks and they're being stored there, that's permitted under B1, correct?
I don't believe so.
Okay, so you don't think that when it says things can be stored on the property, that would include empty fuel tanks?
Now, Mr. Wright, let me just stop you just for a sec. I know you're doing cross fine, but the county hasn't rested its case. My guess is most of what you're addressing, probably for the last 10, 15 minutes, is actually going to be gone into in depth by Mr. Schilling, who's the director of the department, who's charged mostly with responsibility for understanding the code and its ultimate enforcement. What I'm suggesting to you is you may have the wrong witness for your cross.
I just want to lay the groundwork with this witness so
Fine.
that you're familiar with
Okay.
the fact that There's a structure, it's contiguous.
I got it.
They're operating.
I
So-
got it 10 minutes ago.
Okay, all right.
Okay. And this isn't the first case that I've had where there was contiguous property, different uses. I had one last week, so I'm familiar with the issue.
Okay.
Yeah.
And so the violation number 2, you're claiming that you're citing code section 10.1.c, correct?
That's correct, yes.
Okay. And you're claiming that there's been development by placing these materials on the site?
That is correct.
And you're aware that the previous owner was also storing vessels and boats and refuse on the site, and that that's been the case for over 10 years, correct, sir?
I don't know that for a fact. No.
Nothing further of this witness.
Okay.
Your Honor, we'd like to call Paul Schilling, please.
Okay, no redirect then.
Well, actually, yeah, I will do redirect. Mr. Mitchell, have you met with the respondent or with Ryan Helmig in the past?
I have, yes.
Has he told you who lives in that house on that property?
The conversation I had with him was that it was his son, I believe. Yes.
His son lives in the house?
Yes.
Are you familiar with who owns High Time Order Maritime?
It is Ryan Helmig. Yes.
Okay, and he specifically told you his son lives there?
Yes.
Okay, I have no further questions.
Okay, I actually do have one. Do you know the adjacent property, the home, whether Mr. Helmig owns that property as an individual, or does Maritime,
They're in High Order Maritime
High Order.
Incorporated, both.
both properties?
And
Okay.
and that is in evidence, Your Honor, in one of the exhibits, the property appraiser page.
Okay, thank you. All right,
We'd like to call Paul Schilling.
Paul Schilling, all right.
I don't think he's been sworn in yet.
I thought I swore you in. Maybe I didn't.
raised my hand.
All right.
Okay, sorry, Your
Swear
Honor.
or affirm testimony about to give will be the truth, whole truth, and nothing but the truth, so help you God. All right. And your full name, sir?
Paul Schilling,
What's your title?
Growth Management Director for Martin County.
And give us a little overview of what that entails, please.
I had a department made up of 4 divisions with approximately 30 staff at any given time, with administrative division and environmental division, which as you can imagine, deals with PAMPs, preserve areas, shoreline protection zones, amongst other things, and compliance and enforcement, as well as the Development Review Division, which is made up of project coordinators, which in fact shepherd these applications through the development review process. And then I'm overly simplifying all these, but a comprehensive planning division, which is, of course, the long-range planning. From time to time, there are applications by applicants wishing to change the future land use designation on property. We also facilitate the code revisions and land development regulation changes.
How long have you worked for Martin County?
Since 2006,
And since 2006, where have you worked? What department?
growth management.
And can you give us an overview of what you've done in Martin County since 2006?
Sure. So I began my career with the county in 2006 as a zoning compliance technician, answering phone calls and inquiries, hundreds if not thousands of them actually, throughout a few years. I progressed to a senior planner position within the environmental division, in which I was focused on shoreline hardening, permits, any activities relating to building proposals adjacent to environmental sensitive land. And then progressed to a senior planner position within the Development Review Division. I specialized in rezonings and minor final site plan applications successfully. was promoted to a principal planner position within the Development Review Division, in which I took larger projects through the development review process, ultimately to the Board of County Commissioners, the local planning agency. I've also successfully had a career with the Board of Zoning Adjustment for taking items for variances. Progressed to a development review administrator, in which I headed the development review division within the department and oversaw all the activities within that division. Progressed to promoted to deputy director, which I held for a couple years, which I, of course, oversaw everything for the director. And then ultimately, in May of 2020, was promoted to the growth management director. So that's where you find me today.
Your Honor, we'd like to offer Mr. Schilling as an expert in the area of Barton County growth management.
Any voir dire?
No.
Okay, so without objection, Mr. Schilling is qualified as an expert.
Mr. Schilling, are you familiar with the Martin County Code?
Yes.
Is the Martin County Code comprised of 3 different volumes?
Yes.
Do you know what those volumes are?
The Code of Ordinances, the Land Development Regulations, and the Comprehensive Growth Management Plan.
And all 3 of those volumes are called the Martin County Code, is that correct?
That's correct.
Okay. Is there a definition of what's development in the Martin County Code?
There is.
Where is that?
Article 10 of the Land Development Regulations.
Can you tell us what that is and the cite to the provision, please?
So it's section 10.2.b.2. So development means the carrying out of any building activity, mining operation, the making of any material change in the redevelopment or modification of an existing use or appearance of any structure or land, which creates additional impacts, or the dividing of land into 3 or more lots, tracts, parcels, including planning developments and acknowledging all exceptions and subdivisions.
Jerry, can you bring up Exhibit 14 or 15, please? So I'm showing you, Mr. Schilling, what's been admitted into evidence as Exhibit 14. Can you pull up 15, see if that one's better? Okay, let's go back to 14, or that one. Let's go to 13. So looking at Exhibit 13, can you tell me, based on your expert opinion, if what is occurring on this property would constitute development?
Without question.
And can you tell us why?
The property has been improved with there has been clearing of the understory perhaps, but first and foremost, we have a commercial or industrial operation on a low-density land use portion of property. Certainly that crane is not incidental or ancillary to a home-based business. The vessels on the property are a commercial use and perhaps even an industrial use with the salvage or vessels being removed from the water. Perhaps the fuels and oils within those vessels are removed at that site. I don't know that for a fact, but certainly this, without question, is development of land.
So if you are in, say you're in B1 zoning district and you want to use your land to do storage and refuse, can you just use your land?
No, you cannot.
Why not?
The B1 zoning is an old Category C district established by the county in 1967, so it has a limited amount of uses within it. So the idea of simply utilizing that zoning district without any development order or any permits for that matter is not in compliance with not only the land development regulations but also the comprehensive growth management plan.
So when you say without getting a development order, what does that entail?
There are various applications. First and foremost would be an application for this use. Mr. Mitchell mentioned that we did have a pre-application meeting in the past, I believe it was May of last year, in which we detailed the path forward, if you will. Those applications are all the documents associated with development. So as you can imagine, those are the civil plans for drainage, the utilities, landscaping, the environmental components of the shoreline here. We're on a natural waterway, so there are provisions with setbacks from that for uses adjacent to the natural water bodies. There are upland preserve area requirements for 25% of the native upland habitat that would be captured in the preserve area management plans. And the civil utility plans, for example, there would be requirements for the traffic movement within that site to allow emergency services to ingress and egress that site safely. There's probably a requirement for a fire hydrant. There may be requirements for fire sprinklers on that building should it be successfully permitted in the future. There are storage and other requirements for state agencies regarding hazardous material, and perhaps on the vacant ground here, that would not be appropriate to be spilling potentially hazardous material. So there are those documents. There are 12 to 15 individuals, along with the state agencies that participate in the development review process. So it's a complex process, and development in Florida is very, very difficult. And that would be the first step prior to any permitting. There would be acceptance of the infrastructure, the parking area, stabilization, and of course, of utmost importance are would there be any impacts to the river?
Is it fair to say that that process is necessary to protect the health, safety, and welfare of the land, the people in Martin County, and the neighbors to that property?
That's correct. The idea or concepts of simply developing land because of a reason or two, which doesn't meet the code or the comprehensive plan. So that logic is not appropriate.
Are you familiar with Florida statutes 559.955, which is the home-based business statute?
Yes.
How are you familiar with that?
Home-based businesses in the county are a less complicated situation, meaning if I own a home in the county, I can utilize the home-based business license through the tax collector for those uses that are consistent with a home-based business, meaning, so hypothetically, I have a law firm or a law office or an accounting office, and I run a office out of my home. The appearance of the home doesn't change. The impact to the neighbors doesn't change. There are no employees coming and going. There are certainly no impacts to the adjacent neighbors, and that's the protection that is, or the lack of protection here.
There was some discussion about the house that is on the neighboring lot. Are you familiar with that?
I'm familiar with the structure there, yes.
Okay, so if you're going to use that house for a home-based business, what's the primary use for that house and the contiguous lot?
So on the property with the structure there, the primary use would be as a residence, of course, to facilitate a home-based business. So as I said previously, the idea would be, or requirement would be, that I live in the home, I own the home, and I run a home-based business, maintaining the appearance. The second part of that is the adjacent lot does not have any primary use. It has no approvals whatsoever for any activity you see on this property.
So is it fair to say under Section 3.201A that allows for accessory uses, that the accessory use has to be accessory to the primary use?
Yes.
And in this case, the accessory use would have to be accessory to what? The residence or the business?
Could you repeat that?
So the accessory use for the contiguous lot under 3.201, it has to be accessory and incidental to the residence, correct?
Correct.
It can't be incidental to a secondary business, is that correct?
That's correct.
Are you familiar with the Florida statutes?
Yes.
Okay, so under Florida statutes, does the statute specifically say that the activities of a home-based business are secondary to the property's residential dwelling?
Yes.
Okay, so does that fall in line with what our ordinance says as well, that the use on the incidental use has to go to the residence?
That's correct.
And again, have there been any development orders or any development applications for this property?
No.
And have you had discussions with either Ryan Helmig or High Order Maritime, Inc. about this property?
Yes, I believe on one occasion at least.
And what was the gist of that conversation?
It may have been subsequent to the pre-application meeting, which I mentioned, but it was I believe it was a discussion with, or an argument that the B1 zoning simply permitted everything you see here, which is not the case.
And then getting back to the home-based business statute, if you're in the road and you can see the activity from that home-based business that's not in line with the rest of the community, is that allowed under this statute, do you know?
It's not allowed, not that I know of. I would point out that the refuse and storage area mentioned in the B1 zoning is something that is consistent with a commercial use with an approved development order, meaning that there was screening as part of a site plan or an acknowledged storage area.
I have no other questions for Mr. Schilling.
All right,
We do have one or two more after him, though, I will say.
okay. All right,
Sir, I'm sorry.
go ahead, Mr. Wright.
Sir, do you have 559.955 next to you?
I don't. Now I do.
So you've given opinions about whether this is a home-based business on the property. Have you read the statute before today?
I've read it.
Okay, so let's go through it. Do you, in subsection 2, it says a home-based business that operates from a residential property as provided in subsection 3. Do you see that?
Yes.
And is it your contention that the home or the structure on this site is a residential property?
I don't know what the home's utilized for, or even if it's a home, I know it's a structure.
Okay, and at least someone told you that someone's living there, correct?
I did hear that at this hearing, yes.
Okay, well, did you do any investigation to determine whether or not this structure was permitted as a home when it was initially constructed?
I did not.
Okay, but in any event, it may be a home, it may be a business, it may be both, correct?
I guess it could be anything.
Well, you heard Mr. Mitchell's testimony that he claims that CETO or the respondent is operating its business out of that structure, correct?
I did hear that, yes.
Okay. And in this property is in an area zoned for business use, correct, sir?
It has a B1 business zoning district, yes.
Okay. And the adjacent uses on either side of this property are also business uses, correct, sir?
I would need to see the map.
Okay, well, let's take a look at the map.
I'm just going to object to relevance again
Exhibit
about
4.
relevance as to the neighboring properties and what they're doing on their property.
So noted. Go ahead, Mr. Wright, ask your question.
Well, I'm specifically going to be looking at subsection 2, subsection 3C, which talks about when defining whether something's permitted under the statute, whether as viewed from the street, the use of the residential property is consistent with the uses of the residential areas that surround the property. So I'm just trying to establish with this witness that actually the surrounding uses are business uses.
Okay, I'm going to allow that. Go ahead.
You know that in fact the property to the what I'm calling the left, or what direction is that?
Are you talking about to the left of the screen is west, I believe?
Okay, so I'll call that west. So the property immediately west of the house is in fact a business use, correct?
Across the river or residential?
I didn't ask across the river. I'm talking about to the west, adjacent to this property.
Which property?
The one that's labeled B1 on the map that the county put into evidence.
So that's the structure we were just looking at, that property?
Let's
Yeah.
just lay the cursor on the property that we're talking
How
about.
about here?
Yes,
Okay.
that's the property to the west of the home, correct? Or business?
That is a property that's adjacent to the west, yes,
Okay,
southwest, I guess.
and it has also a B1 zoning designation, correct?
Correct.
And then if we go to the east of this, there is also a business or commercial use there up in the blue hatched area, all the way to the top, all the way to the site that's adjacent to this. See it? What is the zoning designation for that property?
I can't read that. I believe it's commercial office residential, perhaps, Core 1?
Or one?
Yes.
Okay. And so you agree that there's no residential use either east or west of the subject property, correct, sir? Other than the house on my client's property?
I can't see under the layer of the zoning code.
Okay. Well, you're the expert. Did you not, in preparation for this hearing, look at the zoning map and the land use map?
I did both, yes.
Okay. So in subsection 3 of the statute that we're looking at, 559.955, it says, "For purposes of this section, a business is considered a home-based business if it operates in whole or in part from a residential property and meets the following criteria." You see that?
Were you on which paren?
Subsection 3, paren 3.
Okay,
You with me
not so,
on the first?
my spot. Paren 3 and then subsection?
I'm just looking at paren 3. I
Okay.
just read you paren 3. We
Okay.
haven't gotten to the subsections.
Oh, I thought
So-
that's where we were before.
If this is a home on the property that we're looking at, and if there's a business operating in whole and part, you don't know that one way or the other, is that right?
On the subject property?
Well, on the immediately adjacent property is a structure, and then on the subject property is the business, correct?
The subject property has no approval to conduct any business. The adjacent property, which has the structure on it, which is utilized apparently according to the owner for his son to live in, could be construed as a residential use, yes.
Okay. And so, the statute applies if the subsections, the following criteria are met, correct, sir?
It would seem so.
So it says, A, the employees of the business who work at the residential dwelling must also reside in the residential dwelling, except that a total of 2 employees or independent contractors may work at the business. You see that?
Yes, that's
not-
paren A.
Okay, and so assuming that my client's son and/or my client live on the property, then certainly, and they are the ones that are doing the work or don't have more than 2 employees, additional employees doing the work, then subsection A is complied with, right?
Allegedly, yes.
Okay. Well, if I put my client on the stand and he says he lives there with his son, then you have no proof to dispute that, do you, sir?
That's correct.
Okay,
Mr. Wright,
yes.
let me just stop you for a sec. I'm struggling with the relevance. You've got 2 properties. They happen to be contiguous. And one of them, which is not the subject of this hearing, could be construed as a home-based business. I think you've established that. I think the county conceded that point. The subject property, even though it's immediately adjacent, is the subject of the hearing. It has no approved uses. It's, for all intents and purposes, would be, except for your client's activities, would be vacant land. How do you get from one to the other?
I'll explain it to you. The statute expressly precludes any enforcement action against a home-based business.
Okay.
It doesn't say a home-based business that solely and only operates on a particular parcel of land, and that cannot include any adjacent property owned by the homeowner. There's no limitation in the statute that says if you have a home-based business, you can't use this section or this statute to protect yourself if you've got two lots and you have a home on one and your business actually operates on both. There's nothing in the statute that says that.
Okay, but what if there's something in the county code which does prohibit the use of vacant land for any use without a development order?
Then if what's being done on the land is a home-based business as defined in the statute, they're prohibited from enforcing their code.
But there's no home on the vacant land.
There is a home-based business that is operating on that land. That's the point I'm making.
It's a
Okay.
separate parcel.
The fact that you can have a home with 10 parcels around it, and if you're operating a home-based business, the government can't come in and say, nope, you can't use your property for this home-based business. If we're using that site for the home-based business, then that site is protected from the code provisions.
And we would concede that for the site with the house, but the other site is unrelated to the site with the house. So we dispute this argument.
Well, I'm going to put into evidence that the property was purchased by my client as in one transaction. There are two parcels listed in the legal description.
Is there a unity of title on those
No.
properties?
There is no unity of title, but my client is conducting a home-based business on two properties. The one that's the subject matter and the home that's immediately adjacent, and under the county's own regulations, accessory uses are permitted to be conducted on a immediately adjoining parcel. That's why I pointed that out with Mr. Mitchell in their own code section 3.210.
If I can respond, the accessory use has to be incidental to the primary use, which is a resident. And the primary use is a residence by the statute that Mr. Wright is citing to, which says the business, if there is a home-based business, it's secondary to the residential use. The county's ordinance allows an accessory use to the primary use, which is a resident. And it is clear from these pictures that Mr. Helmig is not using that property for his residence, he's using it for his business. So under our code, he cannot use that property as an accessory because the primary use is the residence. The primary use is not the business, so it's not applicable in this situation.
We haven't established what the primary use is yet, and
The statute,
witnesses so far, I mean, it's a home, but what there hasn't been any proof as to whether or not primarily what's going on with that structure is running the business or primarily people sleeping there, and so
You're-
that's
Your Honor, the statute provides that.
Wait a minute, Ms. Elder. Go ahead.
we're trying to establish and are establishing that in fact there is a business operating in that structure and in the adjacent site that has been operating that way for quite some time. And they've suggested that,
Let me ask you, how do you get to the adjacency, the contiguity of those properties being the important part? Suppose I had a house here and a vacant lot here. do you agree that on the vacant lot, I couldn't conduct a business without a permit?
I don't agree. I believe if I own a house and an adjacent lot and part of my, and I'm in a business of selling paper out of my house, I believe that I can store paper on the adjacent lot as part of my home-based business, because the fact that I have a home and an extra lot, it doesn't say anywhere in the statute that you're limited to one parcel.
You're,
Okay, but the fact that it doesn't state it means that it isn't there. It doesn't, in other words, I don't know how you're taking a leap that says, oh, I own the adjacent parcel, so I can conduct the home-based business on that adjacent parcel.
100% of the testimony has established that whatever is being done on the subject parcel is being operated out of the structure on the adjacent parcel.
if I may respond. So Mr. Wright is using the argument that our section 3.201 accessory uses enables him to use that second parcel as an accessory to the business. But like I was saying before, that accessory use has to go to the primary use of the property next door. And by the statute, if you look at 559.955, section 3D, the statute specifically provides that the activities of the home-based business are secondary to the residence. That means the residence is the first use. It's the primary use under the statute. Therefore, Mr. Wright's use of 3.201 to try to allow his client to do this is not appropriate, because the primary use is the residence, and they are using that vacant parcel as a primary use, as an incidental use to the business, not the residence. So it's not applicable, and the whole line of questioning is irrelevant, Your Honor.
So I'm establishing two things. One, there's two possibilities. One, it's a home-based business, which is allowed under 559, or two, it's a business under the B1 zoning district that is entitled to use the adjacent lot for its incidental uses. And so if the fact that the house is an office or a structure that's running that business, if the phones ring there, if the mail comes there, if the people that are issuing the decisions about what's coming and going out of the property or where things are stored are making those decisions in that structure, then it could be a business just like any other business that's operating out of a structure, or it could be a home-based business that's operating out of a home. And there hasn't been any clear testimony yet as to which of those two it is. And so I'm arguing both points.
All right, and I understand now better what your point is, but still, the parcel that happens to have the home on it is not the subject of this hearing. And so what I'm focused on is this adjacent lot. And I still don't see how you get to include any business use or any other use on the adjacent lot when in fact but for what's there today would be vacant. It would just be a vacant lot.
If
That's no
the
permits.
if the government takes any action to regulate a home-based business, it's a violation of the section. And so if you establish a rule that this home-based business that in fact is operating on both sites may not operate on both sites, then you violated the statute.
Oh, I don't get there.
Well, the only witness has established that Cito is the one that's supposedly operating this business on the site, out of the house. And so if you stop that business from operating on the site, you've stopped a home-based business.
Okay, I disagree with that.
Well, I'm just asking to put the evidence
Yep,
in.
go ahead.
And so,
Absolutely.
I think we all know where this is headed, but I want to establish my record.
Sure. Of course.
All right, sir. You
Wait a
agree?
minute. You're done with your,
I think you were on cross.
you're still
I'm
on
on cross.
Okay, you're still on cross. Go ahead.
All right, and so, sir, the only parking of vehicles coming and going on the site are my clients and the people who work there, correct?
I don't know that for a fact.
Okay. Well, you don't have any proof that otherwise, correct?
No, you're right.
Okay, and so the fact that there are vessels that are stored there for some period of time and then moved off the property to be processed, and then new vessels put there and moved on, that's something that is allowed under the B1 district, correct?
No, it's not.
So it's your contention that storing these vessels, that this is not refuge or storage areas?
No.
Okay, so when you store these vessels, which are either refuge or not refuge, that are screened from view, you claim that's a violation of the B1 zone, business district?
I'm acknowledging that it's not a listed use. A marine use such as that is not listed in the B1 zoning.
Okay, but in any event, no one's brought a claimed violation of the B1 business district in this case, correct?
That's correct.
I mean, that's not one of the items for today as to whether or not what's being done here is a refuge and storage area, correct?
That's correct.
Okay. And you agree that you don't know what the uses were on the property historically, correct?
Historically, I believe it was utilized in connection with the structure next door, but it's remained fairly vacant for decades, I believe.
And so, do you have personal knowledge that there, as to when boats were first stored on the property?
Not stored on the property. I know just based on aerial imagery as part of the looking at this case that it certainly was not to the extent that it is currently.
Okay. All right, back to 559. Subsection C, which is on the second page. It says, as viewed from the street, the use of the residential property is consistent with the uses of the residential areas that surround the property. Do you see that?
I see that sentence, yes.
So, as viewed from the street, we looked at the picture, which I believe is, help me please, Mr. Mitchell,
The street view. One of the,
go all the way to the recent one from the street.
the street.
I missed something, I'm sorry, I was,
The picture from the Canner right away.
oh, this one?
Yeah,
Yeah,
I got that, oh,
yeah.
this one's fine.
okay,
We're looking at what, 20?
This is exhibit 23 that I showed.
okay.
Okay.
And so, as viewed from the street, the only property adjacent is non-residential property, correct?
If we agree that we're looking west toward the subject property, to the north, I believe, as I said before, I don't know particularly, that's a Core 1 zoning, but I don't know the extent of development on that lot. To the south of this, on the same side of the road, is kind of a historic area with docking and perhaps a fish camp at one point.
Okay. So, as viewed from the street, neither the property to the west or to the east is a residential property, correct?
If we're looking, what do you mean by residential?
Well, are you aware of whether or not the property to the east or the west is residential or not?
As far as the zoning?
As far as anything.
I'd have to look at the map. I don't have it memorized.
Okay, well, let's look at the map. Let's take a look at the future land use map first. Exhibit 3. It's commercial waterfront to the west and commercial office is that commercial office residential to the north?
Yes,
Okay, and do you know whether or not, in fact, that property to the east/north is being used for residential purposes or not?
to the east across Canner Highway.
No.
Okay.
But I'm just trying to describe the the property that's being highlighted by Mr. Mitchell.
To the top of that, I'd have to see it. Do you have an aerial of that area?
I'd have to think,
Are you asking me the zoning on that?
on this one?
Yeah.
We're looking at the land use. The land use designation to the east is commercial office residential, correct?
To the north is commercial office residential, yes.
Okay. And we'll call it then the south is commercial waterfront, correct?
Yes.
Okay, and then D, the activities of the home-based business are secondary to the property's use as a residential dwelling. You see that?
Yes.
Okay? And so, assuming, how do you determine or have you determined whether or not the activities are secondary to the property's use as a residential dwelling?
I think I stated previously they could not be considered ancillary or in connection with a residence. They're industrial and pretty intense.
Well, now you're claiming that storing boats on the property is an industrial use?
Maybe that's the wrong word, commercial use.
Well, it's in a business district, correct? Zoning district.
Correct, with a low-density residential land use.
Okay. And you agree that the land use designation is inconsistent with the zoning, correct?
I agree that the zoning district is not consistent with the low-density land use. That's correct. The B1 is a Category C district established in 1967.
And at least as of today, it's on a 6 or an 8-lane highway adjacent to 2 commercial uses, correct?
It's adjacent to Canner Highway.
And to the north and south, commercial land uses, correct?
To the south is a commercial waterfront land use, yes, and to the north is commercial office residential.
And you don't have any knowledge or proof of any allegedly corrosive or combustible or other hazardous or flammable materials on the property, right?
I don't have personal knowledge, no.
No further questions of this witness.
I have some redirect. Mr. Schilling, if you look at Exhibit 3, the statute talks about the neighboring residential property around this particular area. So if you look across the street from the subject parcel, is there a low-density residential future land use designation there?
Across Canner Highway?
Across Canner Highway?
No, it's commercial limited.
What about if you look diagonal across the street?
Commercial office residential?
Move over a little bit. Jared, can you move the mouse over? The other way, where it says low density right there, the big brown patch. Over here. Over. You want me to take the mouse?
I'm not sure what you're talking about, I'm sorry.
So across the street from the commercial waterfront, do you see that area that's low density?
Yes, I see it.
So if I stand on the corner there, do you know if you can probably see that property from that location?
Yes.
Okay. So is there other residential future land uses near that property, maybe across the water?
Yes.
Okay. Are there houses there?
Yes, there are state homes there.
Has the county received complaints from those residents about the CETO business
We have, in fact.
because they can see it from their property?
Correct.
Okay. I don't have any further questions for Mr.
Just
Schelling.
one bit of redirect, please.
Go ahead.
Sir, let's take a look at the aerial, I think it was from 11/29. Yes. So, sir, you're claiming that the landowners across the river can see the boats on this property?
I've confirmed we've received complaints from the association.
I'm not asking you whether you received complaints. Can you testify that any of those people can see the boats that are tucked in to at least 50 feet of thick vegetation from their property?
I can't testify what they do or do not see. I can testify that a crane or dragline crane is pretty hard to hide.
Okay. Well, nothing further.
Okay.
The county is going to call Clyde Doolin.
Mr. Doolin, if you raise your right hand, do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, and your full name?
Clyde H. Doolin.
Okay.
Mr. Doolin, can you tell us what your title is with Martin County?
I'm the Comprehensive Planning Administrator.
And what does that entail?
My division within the department that Mr. Schilling leads handles amendments to the Comprehensive Growth Management Plan, amendments to the Future Land Use Map, amendments to the Zoning Atlas, amendments to the Land Development Regulations, and special studies.
How long have you worked for Martin County?
Since 1989.
And when did you start working in the Growth Management Department?
1999.
So from 1999, can you just give us a quick overview of what you've done for the Growth Management Department during that time?
Planner 2 in the Environmental Division, Senior Planner in the Comprehensive Division, Principal Planner in the Comprehensive Division, and now Comprehensive Planning Administrator in the Comprehensive Planning Division.
And how long have you been the Comprehensive Planning Administrator?
Since 2017.
And does that require you to work with the Martin County Comprehensive Plan and Land Development Regulations every single day?
Yes, it does.
Do you also get calls from citizens about zoning and uses of property?
Yes, I do.
Can you tell us a little bit about what that entails?
Objection relevance.
We're establishing him as an expert.
I'll stipulate he's an expert if we don't have to go through.
Sure, that's fine by me.
Okay, easy enough. Done.
Great.
Mr. Doolin is an expert in his field.
Okay, can you pull up, Jerry, can you pull up Exhibit 13? Mr. Doolin, I'm showing you what's been admitted as Exhibit 13. Can you take a look at that picture and tell me, from looking at that picture, can you tell if that property is in compliance with the Martin County Comprehensive Plan right now?
No, it is not.
Can you explain why?
There is clearly commercial operations going on the property. The structure, the boats, the cranes, the clearing that's occurred. The land use designation is low-density residential, allowing a maximum of 5 residential units to the acre. It does not permit commercial development.
And are you aware that there is B1 zoning on this property?
I am.
So if someone purchases this property that has an inconsistent future land use and zoning, what needs to happen?
The zoning district needs to be changed to be consistent with the future land use designation because the Comprehensive Growth Management Plan controls if there's a conflict.
Are there provisions in the comprehensive plan that provide that?
There are.
Can you tell us what those are?
Specifically, Policy 4.1A2, Supremacy of the Comprehensive Growth Management Plan. Where conflict arises between the adopted land development regulations and this plan, the goals, objectives, and policies of this plan shall control all land use and development decisions.
Does this happen from time to time in Martin County where a future land use designation is inconsistent with the zoning?
It does.
What happens at that point?
The property owner, if they are seeking site plan approval, if they are choosing to develop their property, seeks a zoning district change to make the zoning consistent with the future land use designation, and then proceeds with site planning consistent with the zoning.
Okay, so what's the future land use designation on this property?
Low-density residential.
And did you tell us what can be done in low-density residential?
Residential units, single-family, townhouse, multifamily, maximum of 5 residential units per acre.
And looking at what's happening on this parcel of property in Exhibit 13, what kind of activity would you classify that as?
Marine industry, commercial marine industry.
Is that allowed in the low-density residential?
It is not.
Are you familiar with Florida's home-based business statute?
I am.
How so?
I've read it. I was following it when it was adopted, and I followed the communication that was happening in the legislature when it was being adopted.
In your opinion, is what's happening on the parcel in Exhibit 13 a home-based business?
No, it is not.
Why not?
The home-based business was intended for people to have secondary, ancillary, cottage industries like baking and such like that operating out of their homes. That's what all of the discussion in the legislature was when it was being adopted. It had no provision for an industrial or commercial marine type activity. To misconstrue this statutory provision to allow just anything would be to throw everything in Florida statute regarding Chapter 163 out the door.
Could the property, the use of the property in Exhibit 13 be classified as a scrapyard or as an extensive impact industry?
It could be classified as an extensive impact industry, yes.
Can you tell us a little bit about that industry?
Our industrial future land use designations in our comprehensive growth management plan designates or describes both limited impact industries and extensive impact industries. Limited impact industries are permitted in the LI zoning, for instance. Extensive impact industries are permitted in the heavy industrial and general industrial. Extensive impact industries are also permitted in the commercial waterfront future land use designation.
Do you know what the definition of an extensive impact industry is?
I don't have it at my fingertips at this moment.
Can you give us an overview of what that entails?
It involves activities that generate noise, dust, and have extensive outdoor storage.
In your opinion, the activities that are occurring on Exhibit 13, do they appear to be ancillary to a residential use?
No, they do not.
I don't have any other questions.
Okay. Mr. Wright?
Sir, you're aware that the comprehensive growth management plan was purportedly enacted by Martin County Ordinance Number 260?
I do not remember the ordinance number.
Okay. And do you recall my client contacting you to see whether or not the county had any proof that in fact the county received a receipt from the state of Florida acknowledging the ordinance at the time it was adopted?
Objection to relevance.
Well, no, I'm going to allow that. I want to know the answer to that, too.
I only remember an email correspondence with your client asking about whether or not surrounding property owners had been noticed, and that's just going by memory. I do not remember the particulars further of the email
Are you aware
exchange.
that the ordinance expressly provides that it only becomes effective upon a receipt from the state of Florida?
I'm aware that today, ordinances must be received by the state of Florida and acknowledged receipt. I'm not aware of what was the procedure in 1982.
Okay, so my client contends that he requested from you and others with the county proof or acknowledgement of any receipt from the state of Florida regarding the comprehensive plan ordinance 260, and that no one could come up with one. Do you know one way or the other whether one exists?
I do not.
Nothing further.
Redirect. Ms. Elder?
Mr. Doolin, did you look for such a receipt?
I did not.
No further.
All right. Let me just ask my question then. So the ordinance that we're talking about was adopted in 1982?
The adoption date of the comprehensive plan originally was April 1st, 1982.
All right. And we don't know whether this receipt requirement was in the law at that point?
I do not.
Okay.
I'm looking for the page, Your Honor. I do, it was in the ordinance. I'm trying to pull it up right now, I'm sure. Yes, it's in part Roman numeral 8. This ordinance shall take effect upon receipt of official acknowledgement from the office of the Secretary of State that this ordinance has been filed in that office. And I'm reading from the ordinance which was adopted the 3rd day of April, 1984, which I believe was ordinance 260.
Your Honor, if that's what if I could ask Mr. Doolin a couple of questions, please, on this issue that I didn't know was being raised until just now?
Will you share that with Ms. Elder? And you don't have to do it this moment, but just make sure that we all get a copy of what you're looking at, okay?
Right.
Yes, it's, and I'll email it to everyone after the hearing. It's
Okay.
part Roman numeral 8 of ordinance 260, which provides when or if the ordinance becomes effective.
Effective date?
Right, yes.
Okay.
Can I ask Mr. Doolin a couple questions? Mr. Doolin, is that a common requirement for ordinances?
It's a common requirement today that all ordinances be received by the Secretary of State.
Right. And do you know if we provide those ordinances and that receipt to, say, Municode before they will codify our ordinances that are adopted?
Yes.
So we do provide that, we have to provide that to Municode, which is the organization that codifies our ordinances. Is that correct?
Yes.
I have no other questions.
I have some follow-up.
Okay.
Sir, are you testifying that you know for a fact personally that the receipt for ordinance 260 from the state of Florida was given to the county and therefore forwarded to the Municode?
I can't testify as to ordinance 260, but I think I can help with something that the comprehensive plan wasn't adopted in 84, as 260 you're referencing was. The plan was adopted in 82, so I think you're citing the wrong ordinance.
Well, the land use element was set forth in 260, correct?
I don't know that to be the case. I thought it was all adopted in April 1st, 1982.
Well, I'm raising the issue. We'll sort that out.
Okay. I have just another follow-up, if I can. Mr. Doolin, how long have you worked here?
Since 1989.
And how long have you worked with the comprehensive plan?
Since 1999.
In all your years here, has anybody ever challenged the comprehensive plan to not being effective because the proper notice was not received from the state?
Objection, relevance.
No, I'm going to allow it. Go ahead.
Not to my knowledge, no.
Have we been enforcing the comprehensive plan as long as you've been working in growth management?
Yes, we have.
Thank you.
All right. Next witness?
Can I call Jerry Mitchell back on something that Mr. Wright questioned him, Mr. Schilling about, like a redirect, please?
Okay.
Or I can wait till after he does his case in chief, whichever you prefer.
No, let's
Do it now?
Now, it's easier.
Mr. Mitchell, are you familiar with you're familiar with the property in Exhibit 13, correct?
Yes.
Have you done a search of the aerial historic views for that property over the course of the years from the Martin County aerial map page?
I have.
Do you have those with you?
I can get them.
Okay, so tell me where you obtained the aerial views that we're seeing the PDFs and Word documents from.
I've obtained these from the property appraiser's website off their general map.
And what does that show you on that general map?
It just shows you the aerial view of each year.
And what year did did Maritime, High Order Maritime purchase the property?
He bought it in 2022.
Okay, so can you pull up the aerial map you obtained in, say, 2021 or 2020?
I'll do 21 right here.
Okay, so can you show us what we're looking at in this document?
What we see here is the subject property. I have highlighted it here, and you do see that looks like there's some boats or something on the property. And then the other property here, the 7290, is the actual house we've been discussing as well.
Okay. And tell us again where you obtained this from?
This is an aerial view from the property appraiser's website.
And you can look at that aerial view from what year to what year?
This one is only one aerial view, but the aerial views go from current back to 1940. There's a few years that they're not there.
Can you pull up the aerial view from 2020? Is this the same type of document that you just described?
Same.
And what year is this from?
This one's 2020.
We would like to move these into evidence, those two documents.
Objection relevant.
To show what?
Mr. Wright questioned some of the witnesses about the use prior to his client obtaining the property and stated it hadn't changed. And we would like to show that these are the two aerial views which are public records on the property appraiser's website for the 2 years prior to when the respondent purchased the property.
Mr. Wright, any real objection?
Relevance.
I'm going to go ahead and allow it. And that's 24
24 and 25.
and 25.
So
All right.
2021 is 24 and 2020 is 25?
Yes. Okay. They're both in.
Thank you. I have no further questions, Your Honor.
Sorry, did she rest?
I rested.
Yes.
We renew our motion to suppress, Mr. Magistrate.
Okay, and it's denied on the same basis I ruled before.
The respondent rests.
Okay. All right, let's go back and look at the exact violations that are being charged here. And that's in Exhibit 18. The violation number 1 is the commercial activity in a residential area delineated on the future land use map. And what was being requested was to apply and obtain an amendment changing the future land use designation on the property from residential to commercial. We didn't have real evidence concerning that particular issue, other than the fact that Mr. Schilling, I think, mentioned early on that, that there were no permits seeking either a change in zoning or a change in the future land use. All right, so I'm going to find that that violation does pertain. Let's look at violation 2. Using the property for CETO business operation is prohibited without an approved development order per section 10.1.c.1. I'm familiar with that section, just having a case that where I had to review it. I am going to find that that a violation there does pertain because there is no permit for the vacant parcel immediately adjacent to the residential parcel. And I understand, Mr. Wright, I understand your argument there, but I think the law treats those two parcels separately. And violation number 3 is storing, parking, keeping items, cranes, structures, boats and trailers, utility trailers, storage containers, fuel tanks, a tractor, other miscellaneous things on the property. I think I saw all of those in violation of section 3.201.a. I did see all of those. And then violation number 4 is an unpermitted aluminum structure, storage containers, and fuel tanks placed on the property. And that's under code section 105.1 of the Florida Building Code, requiring a building permit for those structures is incorporated by section 21.1 general ordinances. And I see structures on the property that even if they're placed there and are not affixed, would need to be properly permitted. All right. Okay, so based upon the evidence and the testimony of the parties, I'm going to find that violations as charged do exist on the property, and I'm going to order compliance. The county had asked for compliance by April 22nd. I think that's an impossibility. I'm going to require compliance on or before, let's see, we're March. I'm going to say by June 30th. It's 90 some days. By June 30th. Failing which, a fine in the amount of $100 per violation per day will accrue. And I am going to award costs in the amount of $575 to be paid to the county at the conclusion of the hearing. Okay, thank you, Mr. Wright. Most interesting morning, and appreciate the argument.
Right, I'll get you a copy of that. Yeah.
I'll send you a copy of the.
Yes, please. Yep. All right. Let's see.
Tim,
That order is right there.
I have the state. I have ordinance 260 and the state.
I don't know.
I just wanted
Yeah, no, I'm fine, thanks.
Yeah, my legal assistant must have been watching. She just sent it to me, so I can email it to you. I haven't looked at it, but she said she sent it to me.
And Mr. Wright, I just signed that order. If you want to grab a copy before you go, you're welcome to do that. All right, let's see. Next case. I've got the Medalist Homes cases. Looks like there are 3 of them. Is that right?
You had 3?
All right. County, need a break, or are you good?
I'm good. If you'd like to see the others.
You're fine?
I'm good.
Okay,
Jeremy's not here.
all right.
We only have a lease for a little bit of time here. So which, is this your first one?
Yeah, let's do 18.
All right, so I'm going to call case number ENG 2023-090018. This is Martin County versus Medalist Homes LLC. It's also a violation case, and let's see. Mr. Bernatsky,
Good morning, sir.
good morning. If you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right, welcome.
Welcome.
Whenever you're ready.
My name is Peter Bernatsky, and I've been sworn in. I'm an engineering compliance analyst for Martin County. The respondent, Medalist Home LLC, is not present at the moment. This case concerns the unassigned property of Lot 17 located in Stewart in Martin County, Florida. This case was not generated by an anonymous complaint. According to the official record of the property appraisers of Martin County, the property owner is Medalist Home LLC. A copy of the property appraiser's record of ownership is marked as Exhibit 1, which is on the screen. Let me zoom in for you.
Yep, got it.
An aerial view of the subject property is marked as County's Exhibit 2. And I'll put that on screen when you're ready, sir.
Okay, go ahead.
This is the aerial of the property, Lot 17 in question, which I am moving my cursor around at the moment.
Okay.
Would you like me to zoom in for you, sir?
Yes, please.
So, property 17 right there, and you can see annotated on it very faintly that it does say 17 on that property. Let me see if I can get in a little bit better for you, sir.
Nope, I can see it. Thank you. Okay. Good.
On August 10th, 2023, Martin County Engineering Services inspectors Phil Cass inspected the property. At that time, he observed partial clearing and fill material placed on the property. Based on the inspector's observation, the amount of fill exceeds 100 cubic yard threshold, requiring a fill permit. At that time, the inspectors photographed Lot 17 that shows the fill material on the lot, and it's marked as Exhibit 3. Maybe.
Okay. Not coming up.
No. close that one. There it is.
Okay, great.
So in this picture, this shows that fill material had been brought in. Now that this picture was taken, there's been some growth, but you can see from where my cursor is to the left, which is going to be a northern direction that I'm moving the cursor, that there is a difference in elevation there,
Yeah.
as well as if you can look at this structure here, the fill has been filled up to about a third of the way of the building, and there is piles of fill material still in back that have not been spread out.
Okay, are those structures, and I see 3 of them.
I believe there's 4 right here, sir.
Okay, well,
So I see one here,
okay,
one here, one here, and one here.
oh, yeah. 4th one was hiding back there. Are
It's,
they on the lot?
They are, sir.
Okay. All right. Okay.
Based upon this investigation, a 30-day notification letter was issued on August 17th of 2023, by certified mail to representative of the property, Jeremy Lemasters. The 30-day notification letter issued at the same time as marked by County's Exhibit 4. At the time that this was put together, there was a total of 8 cases. 5 of those have dropped off. The one that we are looking at is highlighted next to Lot 17, and I will zoom in on that.
Got it.
And this is in violation of Section 4.341B, what is that?
Applicability.
Applicability. I can never say that word, sorry. The return receipt for the 30-day notification was received on August 21st and marked as Exhibit 5. So this is, here's the receipt showing that it was mailed to Mr. Lemasters and that it was delivered. Based on the ground level inspection, additionally, Martin County Public Works required a flight inspection to be conducted on the property based on the request on August 22nd, 2023. Growth Management Department staff Jerry Mitchell performed a flight inspection of the property with the Martin County Sheriff's Office Aviation Unit. The flight inspection photos taken of the subjected properties show evidence of the presence of fill material placed on the property. A markup of the aerial photo is Exhibit 6. So here's Exhibit 6. The lot is marked as best as possible due to the angle of this photo, but you can see in the photo the amount of fill work that has been brought in onto that lot. Where am I at? I was just sitting through. On August 29th, 2023, Martin County Public Works contacted Mr. Lemasters via phone conversation as a follow-up to the 30-day notification letter. As the requirements stated in the letter, Martin County Public Works followed up the conversation with an email to Mr. Lemasters to document their conversation. The email sent to Mr. Lemasters is marked as Exhibit 7.
Okay.
Based on the non-compliance with the notification letter, Martin County Public Works issued a notification of violation to the Medalist Home LLC on October 2nd, 2023 via certified mail marked as County's Exhibit 8. In the notice, Martin County Public Works cited the following Martin County Code violation of Section 4.34.b. Applicable. That word's going to be in my desk. Would you like me to zoom in, sir?
Actually, I've got a copy of it
Roger.
on this laptop, and I'm just following along and reading it too, so, and I can scroll back and forth, so I'm good.
Okay.
All right, go ahead.
In the notice of violation, the respondent was given until November 2nd of 2023 to correct the violations and was informed of the need of contact the Public Works Department to submit a completed after-the-fact excavation and fill permit application. The return receipt of the notice of violation was received on October 9th, 2023, and is exhibit number 9.
Okay. I'm looking at page 2 of that notice of violation. Basically, you gave him, say, 30 days to get his application in, but you also gave him until January 4th, 2024 to obtain the permit in that same letter. Okay. All right, go ahead. And then we've got the Exhibit 9, which is the certified mail receipt. Okay.
Compliance was not achieved in the allowable time provided in the notice of violation, and therefore a notice of hearing was issued by certified mail on November 3rd for a January 17th, 2024 hearing, and that's marked as Exhibit 10. The return receipt for the notice of hearing was received on November 13th and is marked Exhibit 11.
Okay.
No response or application submittals from the property owner was received within the allowable time. On January 11th, 2024, Martin County Engineering Service Inspector Phil Cass inspected the property once again. At this time, he observed no change to the property and conditions remain the same. On January 16th, 2024, Martin County Engineers granted a 30-day extension and the amended notice of hearing was issued by certified mail on January 17th, 2024, and that is Exhibit 12. Return receipt for the amended notice of hearing is marked as Exhibit 13. So this is, once again, for all 8 of the previous cases, that 5 were removed, but this, the highlighted area is for this specific return receipt.
Okay, and are we looking at a U.S. postal receipt? Or
This is from the e-certify mailer that went out. I did not receive callback from USPS for showing that it was actually mailed out, but this does show that it was delivered through our system.
Okay, this is, when you say e-certify, and I'm not familiar with that, that's part of the county's system?
Roger, sir. Yes, sir.
Okay. All right. Okay. Go ahead.
On March 19th, Martin County Engineering Service Inspector Phil Cass inspected the property. At that time, he observed no change to the property. On March 19th, you know what, I missed a whole thing on my,
I
so
didn't mean to break your,
you're right, sir.
Usually start here.
Yeah, no. So we gave him a 30-day to mark, yeah, so. All right, so yes, I'm sorry. On March 19th, Phil Cass inspected the property again, and there has been no change to the property. On March 19th, Martin County Engineering Services verified the property does not have any valid or applied building permits, and that is Exhibit
16.
16. I skipped a bunch. So this is from our seller program, which shows any building permits or any engineering permits, that sort of stuff, and it does not show any current building permits. This screenshot was taken yesterday,
Okay.
and it is timestamped at 9:31 a.m.
Let's go
This
back.
property has also,
I'm going to go back, and you've got Exhibit 15 that is hanging out there, and it's,
oh,
it is a postal receipt.
okay, sorry about that, sir. So yeah, this is just the
That was for the note.
amended notice of hearing for the February 12th to March 20th hearing, which was Exhibit 14. So this is our amended notice of hearing for today's date. And this is the receipt from USPS.
Yeah, and then page 2 has got the exact certified mail. If you just scroll down on that. Whoop. Yeah, there you go.
And it is highlighted showing that this is the one that matches
Okay.
the Acela document from yesterday. I also have another Acela document from this morning that I did not have a chance to get into the exhibit. This shows the date as today of 3/20/24 at 7:54 in the a.m. I'd like to have that as Exhibit 17. It shows it doesn't have it.
I just don't.
Okay.
And it shows that it is exact copy of Exhibit 16, just a different time and date.
Okay, so again, nothing has been filed. Okay, and I'm going to
As of that time, sir.
I'm going to mark that as Exhibit 17. Okay. All right, now, are you done?
So, since this hearing has started,
Yep.
Mr. Lemaster did show up and has told me that he has a building permit application placed in for this lot.
Okay.
I have checked that in Acela, and it is there. But I was also informed to continue this proceeding and bring it in front of you as well. That was placed on, I believe it was at 8:49 this morning is when that got placed into the system.
Okay, and have you verified that?
I have verified that, yes, sir.
Okay. I think the requirement, though, was to obtain a permit, not, I mean, when you cited him back in November, I guess it was, maybe October. Okay, anything else you need to?
As of now, no, I request that all of the county exhibits be received into evidence. And then based on the testimony and evidence, I request the respondent Mentalist Home LLC be ordered to comply with the cited provisions of the Martin County Code by, what is it? April 19th of 2024. and if not comply by, then request pay the fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and request the county be reimbursed for the amount at the conclusion of today's hearing. This concludes my testimony at this time.
Okay, and let me just ask you, before we move on, when you say comply, you're talking about obtaining a permit for this fill, or are you talking about an application?
As I read the code, it is that the
That are required?
building permit needs to be applied for and approved.
Yeah, so it's to obtain a permit. Okay.
Correct.
All right. All right, have you physically been out to this property?
I have, sir.
And have you observed the fill on the property?
Yes, sir.
Okay, because I think prior to that, we have Mr. Cass making some of those statements, and just wanted to make sure you had seen it as well. Okay. All right. Okay, anybody here on behalf of Medalist Homes LLC?
Hey, good morning. Jeremy Lemaster. I was just watching you guys on my phone, and I was able to come back. I was here earlier, but there was a lot of legal. So anyways,
You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, and your full name again?
Jeremy Lemaster,
And what's-
Medalist Homes, Medalist
and-
Building Group,
And what is your affiliation with Medalist Homes LLC?
owner. owner.
Okay, well, LLCs have managers, they have members.
MGMR, president.
Okay, so at least manager, maybe member,
And a member, correct.
okay, all right. So have you heard most of the testimony?
I have, and I've had multiple conversations. So just to kind of throw a little backstory, the previous code enforcement person for engineering was fired.
That was Mr. Cass?
No. What was his name?
I believe it was Clark Bridgman.
Okay.
Mr. Bridgman?
I'm not sure if
Okay.
the actual.
I know his employment was terminated. I don't know if it was on his part or our part, just for the record.
So to make it very
He
clear,
may or may not have been fired, but he's not here.
okay, to make it very clear, he was very hard to communicate with, very hard to actually get responses, unlike Pete. Pete's been great to work with. He's been working, obviously, with our new county engineer, Michael Grzelka. So Pete is aware of the situation. This isn't just a standard lot. This was a whole mobile home park that we've done a lot of renovating and fixing, and Rachel's been out there many, many times for many years with many violations prior to me coming in. She could explain that, but regardless we're actually working towards compliance. There was a lot of survey and engineering that had to be done prior. That took quite a bit of stuff to get done. Unfortunately, we are on well and septic, so the elevations that we're having to do are higher, and we have to demonstrate compliance, obviously, to the engineering department, which actually is a lot of engineering calculations and making sure we meet compliance. So Pete's very aware of this situation along with the other lots also.
All right, let me take you back a little bit. County submitted, asked me to accept into evidence Exhibits 1 through 17. Any objection to any of those? It's the paperwork, it's,
I wasn't here for that personally, so I don't know. I just heard it audibly. So
okay.
if you want to go through each one, I'm more than happy.
Well, you're welcome to, otherwise you can just
Sure,
say
just
no
show me the
objection.
picture of each one, and I'll tell you yes or no.
Okay. All right, quickly, Exhibit 1 is,
And just for the record, I did ask for a request of further than a 30-day extension, and it was denied by engineering department for only 30 days.
okay, so,
Would you like me to run through these, sir?
yeah, go ahead.
So Exhibit 1.
Yeah, that's fine.
Exhibit 2,
That's fine.
Exhibit 3,
That might be on the lot next door, but it's irrelevant. We're going to be compliance anyway, so it's fine.
Exhibit 4,
That's fine.
Exhibit 5,
All right, that's fine.
Exhibit 6,
That's fine.
Exhibit 7,
Yeah, that was something that Clark did. That's fine.
Exhibit 8,
Okay,
Exhibit 9,
that's fine.
Exhibit 10,
That's fine.
Exhibit 11,
Okay,
Exhibit 12,
that's fine.
Exhibit 13.
Nate, real quick, when did you take over, Pete?
I believe it was just in January.
Okay, so was
I don't
the,
know the exact date.
but the previous one, was that from you, or who was that from?
This one right here? Mm-hmm. Or, so the notice, the original notice of hearing was from Clark. The amended notice of hearing would have been from me.
Okay,
So that first amended notice of hearing is when I took over. I believe it was 3 days prior to this, so that Monday.
okay.
And
Yeah, that was right when you just took over and you're, yeah, juggling everything. Okay, I remember that.
so Exhibit 13 is the
I-
receipt.
Okay, I can't even tell on that. That's fine.
Exhibit 14, new amended for this court hearing,
Okay,
or magistrate hearing. Your return receipt. Sell a document from yesterday,
Yep.
yesterday, showing that was not in yet.
yeah. You and I talked about that this morning.
Correct.
That's
And then
fine.
there's
Exhibit
one more.
17,
which I have up here, Mr. Lemaster, and I'll show it to you. It's the same, pretty much as 16, except the date stamp on the lower right-hand
Yeah, that's
corner.
just showing that we submitted for the permit. That's fine.
No,
that shows that the permit was not submitted for at that.
that was as of,
Okay, but what's the difference between Exhibit 16 and what he's saying is Exhibit 17?
The
just the
only,
date
only
stamp.
difference is the timestamp.
Okay,
The timestamp on Exhibit 17 shows today's date at 7:40.
That's fine.
In the morning.
And, let's see, Mr. Bernatsky did testify that in fact he had checked the record, the county's Excel record.
Roger, yes, sir.
Can you bring that up on the screen? I'll bet you can't.
It'll take me a moment, sir, but yes.
well, I heard when I was driving that, you know, he brought it up and then we got it submitted this morning to like 8:40 something.
All right, so without.
That's fine, and then I talked to him this morning before, or about like 9:15 maybe?
Yes.
So he was aware of that too. That's fine.
All right, so without objection, I'm going to accept into evidence
Yeah.
the county's exhibits 1 through 17. Do you have anything else you need to tell me? Any questions?
Well, I've asked multiple times why Clark was fired because we kept on experiencing a lot of,
That's not relevant.
it's irrelevant to time because if you don't have communication, you don't have anything. Okay? Clark has done great communication. Mike Rozelka is the county engineer and he has to go through, excuse me. I got to clarify this. So Clark had horrible communication. Pete has been great with communication and actually calling you back, emailing you back, and communicating, whereas Clark was not any of that. One email from Clark does not suffice.
When I say it's not relevant, what I'm talking about is from the evidence and all of the testimony, including you not refuting it, I see fill on a property without a permit. That's relevant. And based upon that, I'm going to find that a violation does exist on the property in order you to comply. And I think April 19th may be a little tight.
There's no way that we're going to have our permit actually issued by then.
Okay.
I mean, unless Pete can do a review and we get out the first time.
I think I'm going to,
But again, I just want to make it very clear, I asked for an extension further than 30 days, and I was only denied 30, I was only granted 30 days, knowing that we still had to get surveying done and still had to get engineering done, and I was told that we needed to comply.
all right, I'm going to give you until May 31st to comply. So That should be enough time to do that. All right, failing which, a fine in the amount of $100 a day will accrue, and I am going to award costs in the amount of $575 to be paid to the county at the conclusion of the hearing. So your new compliance date is May 31st.
Okay.
The lake lot and
Okay.
lot 20.
Okay. That's fine.
All right. Do I see your name, yeah, on another one or two of these?
Yes, sir.
Okay. All right. Is MCFL also, Mr. Lemaster, is that you too? Yes, it is. Okay, I'm going to call that one next, then. It's case number ENG 2023-090021. The respondent is MCFL Holdings LLC. And what have we got there?
My name is Peter Bernatsky. I've been sworn in. I'm an engineer compliance analyst with Martin County. The recipient, MCFL Holdings LLC, is present. The case concerns an unsigned property identified as Lake location in Stewart in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official record, the property appraisers of Martin County, property owners, MCFL Holdings LLC. A copy of the appraiser records ownership is Exhibit 1.
Okay.
An aerial view of the subject property is marked as County's Exhibit 2. And it is this location here. Zoom in for you. And it does say lake on the property.
Okay.
On August 10th, 2023, Martin County Engineering Service Inspector Phil Cass inspected the property. At that time, observed partial clearing and fill material placed on the property. Based on the inspector's observation, the amount of fill exceeds 100 cubic yard threshold, requiring a fill permit. At that time, the inspector photographed the lake parcel that shows the fill material on the lot and is marked as County Exhibit 3. So property line is approximately right here, sir.
Okay, and you're...
There is fill also on the other side of this pond as well.
All right, and is the pond on the property?
The pond is its own parcel, and the pond takes up 3/4 of that parcel. 3/4 to 75%, well, 80-ish%.
But it's not the parcel shown in Exhibit 1?
No, it is the parcel shown in Exhibit 1.
It's all part of the
So-
same piece?
Roger, sir. So on Exhibit 2, zooming in on it, the lake falls within this area here, within that parcel.
Okay, and where is the fill?
The fill is in this location here, where my cursor is moving back and forth right now,
All right,
and also in this location here.
okay, and the fill on the, what would that be, the west side, I guess, or the northwest side, encroaches on the pond?
Yes, sir.
All right, and
So part of the pond was filled in.
is the pond a wetland?
I am not aware that it is a protected wetland, no.
Okay, all right. All right, that's not part of your case. Go ahead. We're looking at the fill.
So we are past Exhibit 3. Based upon the inspection, investigation, a 30-day notification, Letter was issued on August 17th by certified mail to the represented property, Jerry Lee Master. The notification letter at this time is marked as County Exhibit 4, which is not the right letter. No, it is. So, and highlight is showing the lake.
Okay. Same letter, different parcel.
Roger.
Good.
And this is stating that it violates section 4.341B applicability.
Ooh, very good.
I got it. It's only taken 8
Nailed
times.
it.
A return receipt of 30-day notification received on August 21st, 2023, and is Exhibit 5. Once again, showing that it was delivered. Based on the ground level inspection, additionally, Martin County Public Works requested a flight inspection to be conducted by the property. Based on this request, on August 22nd, 2023, Growth Management Department staff Jerry Mitchell performed a flight inspection of the property with the Martin County Sheriff's Aviation Unit. The flight inspection photos taken of the subject property show evidence that the proposed fill material placed on the property and is marked up and is Exhibit 6.
All right.
So in this photo, you can see how the amount of fill has encroached on, that would be the north edge of the property. You can't really see it on the south edge, but there is fill on the south edge as well. Based on noncompliance with the notification letter, Martin County Public Works issued a notice of violation to MCFL Holdings LLC on October 2nd, 2023, via certified mail marked as County's Exhibit 8. May I backtrack for a moment, sir? On August 29th, 2023, Mr. Bridgman contacted Mr. Lemasters via phone, having a conversation as a follow-up to the 30-day notification letter and requirements stated in the letter. Mr. Bridgman followed up the conversation with an email to Mr. Lemasters to document the conversation. The email sent to Mr. Lemasters is marked as evidence or exhibit number 7. So. Based on the noncompliance with the notification letter, Martin County Public Works issued a notice of violation to MCFL Holdings LLC on October 2nd via certified mail marked as County's Exhibit 8. In the notice, Martin County Public Works cited the following: Martin County Code violation of Section 4.34.B. Applicability.
Okay.
The violation, in the notice of violation, the respondent was given until November 2nd to correct the violation and was informed of the need to contact Public Works Department to submit a completed after-the-fact excavation and fill permit application. The return receipt for the notice of violation was received on October 9th, 2023, and is Exhibit 9. Compliance was not achieved in the allowable time provided in the notice of violation, and therefore a notice of hearing was issued by certified mail on November 3rd for the January 17th, 2024 hearing, and is marked as Exhibit 10. The return receipt for the notice of hearing was received on November 13th and marked as County's Exhibit 11. No response or application submittal form for the property owner was received within allowable time. On January 11th, 2024, Martin County Engineering Service Inspector Phil Cass inspected the property. At that time, he observed no change to the property. Conditions remained the same. On January 16th, 2024, Martin County Engineers Service granted a 30-day extension. The amended notice of hearing was issued by certified mail on January 17th for the February 21st, 2024 hearing and is marked as Exhibit 12. The return receipt for the amended notice of hearing is marked as Exhibit 13. On February 28th, 2024, Martin County Engineering Services granted an extension. The amended notice of hearing was issued by certified mail on February 28th, 2024, for the March 20th, 2024 hearing and is marked as County Exhibit 14. Return receipt for the amended notice of hearing and is marked as Exhibit 15. On March 19th, 2024, Martin County Engineering Service Inspector Phil Cass inspected the property. At that time, he observed no change to the property and condition remained the same. On March 19th, Martin County Engineering Service verified that the property does not have a valid or a applied building permit, and this is Exhibit 16. Once again, this is the Acela document. Bottom corner is time-stamped as of yesterday. I have Exhibit 17, which is from this morning, and this is time-stamped at 7:47 of 3/20/2024.
Okay. Do you want to show that to Mr. Lemaster, please?
No, that's fine.
I request that all the county's exhibits be received into evidence. Based upon the testimony and evidence, I request the respondent, what is it? Sorry. MCFL Holdings LLC be ordered to comply with the cited provisions of the Martin County Code by, I'll change it to the new date that you gave, sir, which is May 31st. I believe that was the date.
Yes, it is.
We'll change it to May 31st. And if not complied by then, be requested to pay the fine in the amount of $100 for every day that the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and request that the county be reimbursed for the amount at the conclusion of today's hearing. This concludes my testimony at this time.
Okay. Mr. Lemaster, you've been sworn in. Do you have any objection to Exhibits 1 through 17 in this case?
There's actually a number, and I don't want to be argumentative, but the lake was not filled in. The property line is not correct on the top. Pete and I I've talked to him about that. I actually had a meeting with Michael Grzelka and the Christian Phoenix, the engineer, which I don't know if you're aware of that, about a month ago, Pete? So we actually had a meeting to come up with a game plan of any additional stuff that he needed. Like I told him before, the lake was not filled in. That was the property next door of Lot 22 that there is no case on that, other than we're getting our building permit, and Lot 18, which is what we're getting our building permit.
So look at Exhibit 3. Let's look at that. Tell me what that shows.
That shows fill on the edge of lot 22.
All right, and maybe you can direct that cursor just to show where you think the edge of the lot is.
Well, if you go to an aerial, it's
Okay,
better to go that way.
we can do that.
So if you look to the right, you got the neighbor's building.
To the right.
No, the guy built a new building across the street. Well, that property line goes directly across the street from the edge of his building.
Okay, so you're saying the boundary line that's drawn on Exhibit 6 is not accurate?
Correct. See, in our building permits, we actually show the edge of the lake in lots 22 and lot 18, and lot 19 is not part of this, and lot 20 actually has that, a part of it also. And lot 20, we're waiting on the building plans to come back to submit for lot 20.
All right, if you, looking at Exhibit 6, if you adjust the red line that's closest to
All right, so
arrow-
you guys can see, okay, if you go across, okay, it's in front of his building. If you go back to your aerial, he has it way past where his building is. It's not correct. Again, I'm not trying to be argumentative, this is just sheer facts. We had multiple conversations about this with Michael, and, we're showing each property line with a portion of the lake, just so they're showing everything, because they want offsets and they want everything on it. But again, this is a moot point, because we're showing it going around the whole lake.
All right, let me ask you about the relevance of that. How does that affect the case where you have deposited fill on the land without a permit?
We didn't put fill on the lake parcel. The lake parcel is a separate parcel. We put fill on lot 22 that I stated prior, and on lot 18, we didn't even put fill on that corner up against the lake. Clearing the overgrown brush is not putting fill on the south property line. Again, I'm not here to argue, these are just sheer facts.
We want to get this right, so,
Because, if we're going to waste our time going through some irrelevant stuff, I just want to, that's why I actually came back, just so I can actually tell you the truth, because I'm not just going to get hammered by non-facts. Because Clark should have been here, but he got fired.
well,
Once again.
or at least he's not here.
Okay, well, I'll do a public request and we'll find out.
Your Honor, Mr. Grizelka is here if Your Honor wants to hear from him, if he can clarify this issue.
Okay. That's fine. Good morning, Mr. Grizelka. If you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, so you're familiar with this property,
Yes, sir.
and you've heard what Mr. Lemaster has alleged, basically that we got the wrong property in front of us.
No, I'm not saying that.
Oh, I thought that's what the net result was.
No, you're saying that we put fill in the lake, which we didn't. We put fill on lot 22
Up to the lake.
in lot 18, correct. And that's, I had a meeting with Michael and the engineer, and we went over exactly. He wants me to do a separate permit, which we're doing part of our building permit, which is what the previous cases were. So we're combining it all, so we're not doing a fill and excavation. We're just doing a building permit.
Okay, go ahead.
Just so we're clear.
Mr. Grizelka, go ahead. What can you contribute?
From all of our investigations and from my department and all, it's apparent, or it appears that, yes, there's fill on every single lot, including the lake parcel. What our conversation had been is that we had requested him, Mr. Lemaster, to come in and obtain X and fill permits for every single lot. He, during our meeting, requested that he could do could he do building permits on those lots? And I agreed, yes, you could do the building permits on all the lots except for the lake parcel. And he said, well, we didn't fill in the lake parcel. I said, well, you at least need to then show us with a survey that you did not affect the lake parcel.
And has he done that?
No, sir.
Okay. All right. And do you have a survey that shows that the lake parcel is not been filled?
I don't believe Christian said that he had that one after. I don't believe we do.
I've never seen anything.
Yeah, I don't think that we do, because when we did it, well, we set up a meeting just to go through everything, because again, you know, the engineering department was ran completely different prior to Michael coming, which is why Michael's here, and he's done a great job. So, you know, it's just dialogue and communication, which is actually what we're actually getting now.
Okay.
So, you know, again, you know, for Michael stating that, I agree with that, but we're actually showing that on lot 22 and 18, you know, referencing that, because we actually show, and Pete could, because he's doing the review, could show that we have the lake parcel, you know, next to each one, because we have to show it all the way around.
All right, let me just say, I don't view this as you being hammered by non-facts, so I'm going to, even over your objection, I'm going to accept into evidence the county's exhibits 1 through 17 in this case. Based upon that evidence and all of the testimony, yours as well as the county's, I'm going to find that a violation does exist on this property in order compliance on or before May 31st, 2024, failing which a fine in the amount of $100 a day will accrue. I am going to award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. And it may turn out, if you produce that survey and this becomes a nullity, that in fact you will have complied by virtue of your survey. If you can prove that to the county, then of course, then there's not ever going to be a fine in this case.
Well, there's no harm of actually doing a continuance for us to actually get that if that's requested.
Yeah, no, I've seen enough evidence, and you have not produced any evidence refuting it.
I'm objecting to it very clearly on the record.
I,
Maybe you didn't hear me, but I told you that lot 22 actually had the fill, and if you show me a property line that goes through and shows me that lot, I'll agree with you, but I don't,
Okay.
because it's not the facts.
and just understand, you're not a surveyor. You didn't put yourself forward as a surveyor.
But I am a licensed state certified building contractor. I know where the property lines are, and we actually are very aware of these property lines. But you have not shown me not one property line that goes through showing that fill. And I'm not trying to be argumentative, but this is just
Well, you
sheer
are.
facts.
I've already ruled on the case, so you can do with that what you want to do. But my recommendation to you is to bring your proof of that into the Public Works Department so they can deal with the fine component of it, and they may very well get rid of it. So, okay. All right, next case. And the next case is also you, right?
If it's lot 20, because that goes with the lake.
Okay,
We're going to show that together on the lake again.
all right, just a second. Let me get there. All right, this is case number ENG, sorry, 2023-09-0023, and it's Martin County versus Medalist Building Group LLC. And Mr. Bernatsky, whenever you're ready.
My name is Peter Bernatsky, and I've been sworn in. I am a engineering compliance analyst for Martin County. The respondent, Metalist Builders Group LLC, is present. This case concerns the unassigned property at Lot 20 located in Stewart in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official record, the property appraisers of Martin County, the property is owned by Metalist Building Group LLC. A copy of the property appraisers is Exhibit 1.
Okay.
An aerial view of the subject property is marked as Exhibit 2. Highlighted in blue.
All right.
On August 10th, 2023, Martin County Engineering Services Inspector Phil Cass inspected the property. At that time, he observed partial clearing and fill material placed on the property. Based on the inspector's observation, the amount of fill exceeds the 100 cubic yard threshold, requiring a fill permit. Based upon the inspector's investigation, a 30-day notification letter was issued on August 17th, 2023, by certified mail to the recipient of the property, Jeremy LeMasters. The notification letter issue at this time is marked as County's Exhibit 3. The number is highlighted in yellow.
Same letter, different lot. Okay.
In the notification letter, Martin County Public Works cited the following Martin County code violation of Section 4.341.b. applicability. The return receipt for the 30-day notification was received on August 21st, 2023, and is marked as Exhibit 4. Based on the ground level inspection, additionally, Martin County Public Works requested a flight inspection to be conducted of the property. Based on the request, on August 22nd, 2023, Growth Management Department staff Jerry Mitchell performed a flight inspection of the property with the Martin County Sheriff's Office Aviation Unit. The flight inspection photos taken of the subject property shows evidence that the presence of fill material placed on the property. Marked up aerial view is Exhibit 5. So in this photo, you can see how the fill material is, you can see it through the trees.
Okay.
On August 29th, 2023, Mr. Bridgman contacted Mr. LeMasters via phone conversation as a follow-up to the 30-day notification letter and the requirements stated in the letter. Mr. Bridgman followed up the conversation with an email to Mr. LeMasters to document their conversation. The email sent to Mr. LeMasters is documented as Exhibit 6. Based on the noncompliance with the notification letter, Martin County Public Works issued a notice of violation to the Metalist Building Group LLC on October 2nd, 2023, via certified mail marked as County Exhibit 7. In the notice, Martin County Public Works cited the following Martin County code violation of Section 4.341.b. applicability. In the notice of violation, the respondent was given until November 2nd, 2023 to correct the violation and was informed the need to contact the Public Works Department to submit a complete after-the-fact excavation and fill permit application. The return receipt for the notice of violation was received on October 9th, 2023, and is marked as Exhibit 8. Compliance was not achieved in the allowable time provided, and the notice of violation, and therefore a notice of hearing was issued by certified mail on November 3rd, 2023, for the January 17th, 2024 hearing, and is marked as Exhibit 9. The return receipt for the notice of hearing was received on November 13th and is marked as County's Exhibit 10.
Okay.
No response or application submittal for the property owner was received within the allowable time. On January 11th, 2024, Martin County Engineering Service Inspector Phil Cass inspected the property. At that time, observed no change to the property and condition remained the same. On January 16th, 2024, Martin County Engineering Services granted a 30-day extension. The amended notice of hearing was issued by certified mail on January 17th for the February 21st, 2024 hearing and is marked as County's Exhibit 11. The return receipt for the amended notice of hearing and is marked as County Exhibit 12. On February 28th, 2024, Martin County Engineering Services granted an extension. The amended notice of hearing was issued by certified mail on February 28th, 2024 for the March 20th, 2024 hearing and is marked as Exhibit 13. The return receipt for the amended notice of hearing is marked as County's Exhibit 14. On March 19th, 2024, Martin County Engineering Service Inspector Phil Cass inspected the property. At that time, he observed no change to the property and the conditions remain the same. On March 19th, 2024, Martin County Engineering Services verified that the property does not have a valid or applied building permit, which is Exhibit 15.
Okay.
Once again, this morning on 3/20/24 at 7:44 a.m., that request or that was validated again, that there is no valid or applied building permits, and I'd like to have that as Exhibit 16. I request that all of the county's exhibits be received into evidence.
Thank you.
Based upon this testimony and evidence, I request that the recipient Medalist Home LLC be ordered to comply with the cited provisions of the Martin County Code by May 31st, 2024. If not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting the investigation and requires that the county be reimbursed. This amount at the conclusion of today's hearing. This concludes my testimony at this time.
Okay, so Mr. Lemashka, you've heard the county's request that I accept into evidence the county's exhibits 1 through 16. Any objection?
I don't believe that there's any objection. I mean, again, the property line might be a little off, but I mean, again, I'm not arguing that there's some fill on there.
Okay. So without objection, I'll accept into evidence the county's exhibits 1 through 16. Go ahead.
Well, Pete and I have had many conversations. This lot's a little bit unique because it's kind of like square and then cockeyed, and then you can only have like a 25-foot wide building. Even though it has trailers on it, we're actually trying to comply to today's standards. And we're still waiting for those building permits, or the building plans to get back, which Pete and I have had conversations for the last, I don't know, what, 2 weeks? 3 weeks?
Week and a half.
Yeah, I said that I wasn't going to be able to meet this deadline, but he said that it wasn't his deadline. We actually requested to get an extension just to get a little more time to actually get the plans to submit, which Pete told me he was told to just continue on.
Well, you really, when I look at the cases in some, I mean, you've had since August notice that you'd put fill on the property without permits. So, I mean, you've had enough time. I don't, and I'm
Can I ask you a question?
giving you a
So
little
what
more.
what is the county's protocol on extensions?
I have no idea, and I'm sure it's case by case, but I have no,
Okay, so then
Real
it would be
idea.
discretionary.
it's not something that I would even deal with.
Okay, so if an applicant asks for a request of extension of time in writing, and it is denied or verbally and denied, there is no protocol?
You'd have to ask them.
Because I mean, Pete can say, or I can ask the question, Pete, how many times have I had this conversation saying I'm waiting for the building plans to come? I can't submit without it because I don't want to submit an incomplete application.
So saying that you do not have your building plans or your ability to complete the application process is not a formal request to extend out the process. You have been given 2 extensions previous to today's date. Once you were supposed to, or once there was a January hearing and then also a February hearing that were both extended. That's a total of 60 days alone.
But extension with you one time. I was working with Clark and Michael Grzelka wasn't in this at all.
The January extension that was placed was actually from me. So the January hearing was, Clark left the county previous to the January.
But wasn't that like a day or two?
You were still given an extension of 30 days after that, so.
And then I requested a meeting with Michael Grzelka, which I believe it took about 2 weeks to set something up, if I'm not mistaken. Mike, you can speak, but it was Michael and myself and the surveyor and his assistant to actually get a real game plan of submittals. Then after that meeting, we got, how many would you say we got submitted? 6 after that meeting, that we had the game plan, and there was some stuff that we needed additional information, and here we are. So this is not me playing a game or anything. This is.
All right.
So you are correct.
But understand, the significance is that back prior to August, when the county observed this, the land had been filled without a permit. So I mean, you
There was
really.
fill, yes, there was fill brought onto the site. Again, I'm not arguing the different amounts. I'm not going to get into that technicality of fighting. That's not the point. The point I'm trying to make is the engineering department was in shambles before Michael Grzelka came in.
Okay.
So when you,
Objection as to relevance.
Yeah, it's.
well, if you're a
not
citizen
relevant to the-
that's applying for building permits, that is irrelevant. That is irrelevant.
Hang on,
It is.
through me. Through me. You want to argue a case, you do it through me, not direct. Let me explain. I don't want to put words in Ms. Elder's mouth, but the significance is that for it to be relevant, it would have had to have affected your ability to obtain a permit prior to filling the property. We don't have any of that. We don't have any of that. We've got you filling the property, you getting caught by the county, them noticing you starting in August, and here we are in March. So, this may be one of those cases where it's not better to get, permission than forgiveness. It may be better in this case to get permission.
Well, I'm not arguing those facts. I'm just saying is the engineering department was not as good as it is today, not even close. That's why Michael's here.
Okay.
And that's why you actually have staff here to actually help them, and they actually respond and get back to you in a reasonable amount of time. The previous engineering staff and Clark did not communicate stuff, but maybe a one-line email.
Okay, but nonetheless, you took it into your own hands, did kind of a self-help thing, filled the property, no permits. And that's what this really comes down to. So based upon the evidence, your testimony, theirs, I'm going to find that a violation on this lot does exist as well, and order compliance on or before May 31st, 2024, failing which.
We're actually in the
a fine-
process of getting
A
compliance.
fine in the amount of $100 a day will accrue. And I'm going to award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. So I wish you luck. I hope you get your permits and it all works out the way it's supposed to. But had you done that prior to the fill, we wouldn't be here. We wouldn't be here, and you wouldn't be paying costs, and you'd be doing your business, whatever that is.
Well, this is agricultural land, and I honestly wasn't thinking that. So, and I talked to code enforcement, and that's actually how this came about also. And then they said, hey, you need to go do this. I said, okay, again, staff's been good after Michael took over, but prior, it's public knowledge.
Okay.
It was not very good.
Well, you've made your point, and appreciate it. Thank you very much.
Okay.
Good luck to you. All right,
Thank you, Your Honor.
take a 5-minute recess? Yeah, we're going to take a 5-minute recess. Thank you very much.
039-01.
039,
Said do not repeat.
American Stars and Stripes LLC. Yes? All right. All right, so this is case number ENF 2024-020039-01, Martin County versus American Stars and Stripes LLC. And I see we got some folks here. Sorry, I guess you've been here all morning, haven't you?
Yeah, it has been all morning, and
Yeah.
also didn't get enough sleep, so I'm a little fatigued.
Well, I apologize for the time delay, but you saw what occurred this morning, so you know it was unavoidable. All right, this is a violation case.
Yes.
No, it's a repeat violation, so we're going to hear from the county first.
Okay.
And then I'm going to swear you all in, whoever's going to testify, and then we'll go from there. Actually, I've got to swear you in too. So if everybody, just go ahead and raise your right hands. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. All right, so you've all been sworn in. And Ms. Espiat, whenever you're ready.
Okay. My name is Maria Espea, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, American Stars and Stripes LLC, is present. This case concerns a property at 943 Northwest 16th Place in Stuart, Florida, and Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is American Stripes LLC. A copy of the property appraiser's record of ownership is County's Exhibit 1. A magistrate hearing was held on September 19, 2019 for the case ENF 2019-070-108. An order not to repeat violation and to pay costs was ordered. In this order, the owner was ordered not to park any vehicles on county right-of-way. The recorded order to not repeat is County's Exhibit 2.
Okay, and let me look at page 2. Okay, and there was a sign violation too. All right, go ahead.
On February 1st, 2024, I received a complaint about cars being parked on the right-of-way. The complaint had a picture attached, and it's County's Exhibit 3. This right here shows these two vehicles on the right-of-way. This is from the complainant. On February 2nd, 2024, I inspected the property. At that time, I observed cars on the right-of-way. At that time, I photographed the property. The photographs accurately show what I saw then, and they're marked as County's Exhibits 4 through 7. Here's one on the right-of-way. Here's a second one. Exhibit 5 shows a different angle of the same vehicles. Exhibit 6, just a different angle. Exhibit 7 shows you that everything past that blue line to the street, to the road, is right-of-way. And that's from the Martin County GIS maps. I went back to the property on February 7th, 2024, and seen the violation remained. The inspection photo is marked as County's Exhibit 8. Here's the vehicle on the county right-of-way.
Can you blow that up, please?
Yes.
Okay.
Therefore, on February 21st, 2024, I issued a notice of repeat violation to the owner, and I also mailed the same day a repeat notice of hearing by certified mail and regular mail. The notice of repeat violation and the repeat notice of hearing are marked as County's Exhibits 9 and 10. That's, number 9 is the repeat violation notice, and the repeat hearing notice is number 10. On March 5th, 2024, I re-inspected the property and seen the vehicles had been removed from the right-of-way. This inspection is County's Exhibit 11. I'll zoom in for you. All the vehicles are removed from the county right-of-way. The return receipt was not returned, so on March 6, 2024, I posted the property on the Martin County Admin Building. The affidavit of posting is marked as County's Exhibit 12. I request that all of the county's exhibits be received into evidence based upon the testimony and evidence. I request that the respondent, American Stars and Stripes LLC, be ordered to pay the repeat violation fine in the amount of $8,000 for the 32 days the property was in violation. The county has incurred a cost in the amount of $575 conducting the investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. Any objection to my accepting into evidence the county's exhibits 1 through 12 in this case?
Yes, my name is Engin Karabulut, and my company, American Stars and Stripes, owns this property. And I rent it to my tenant, which is the Affordable Car Care. And now naturally, this has been addressed to me, and I happen to be the property owner.
Yes.
So if the car has been parked there, it's not my doing.
Gotcha.
And I
Guess
took-
what?
Yeah.
As property owner,
Right. I took that up.
you're responsible for whatever happens on the property.
Yes.
Now, if I fine you or fine them, how you get the money from them is your business. But I'm not hearing an objection to the county's exhibits. I think you're just making your argument.
Well, my argument is simply this. I understand the stature or whatever, she was talking about, but I do respectfully disagree with that simply because all the county has to do is make a phone call, which will take 10 seconds, to the tow company, like Kaufman or someone else. They would be glad to come and tow these cars if they are parked there, and it wouldn't cost a penny, not a cent, to county. I mean, I've seen cars before parked in the easement, and then the police comes in and then puts a pink slip there and saying that these cars needs to be, removed in about like 24 hours, and if they are not, they will be towed. And the tow company comes in the next day and they tow the cars away, and they are delighted to do that, and they put it, in their lot or what have you, and then the owner has to come and retrieve the car. It's
Let me
that
just
simple.
stop you for a second.
So why am I being
Wait a minute.
penalized for
Wait a
that?
Hang on just a sec. I'm just going to stop you for a sec. I'm not hearing an objection to the exhibits. I'm going to accept them into evidence, but I think what you're arguing is there are other means of enforcement.
Yes.
Well, there are. I mean, there's probably 4 different ways that I can
They're
think
much
of.
simpler than what we are doing right now.
Maybe, but it's the county's choice, not yours, not mine. It's the county's choice how it wants to enforce its ordinance. And I hear you. If it's on public right-of-way, they can call the sheriff's department, get them
Exactly.
to cite it and tow it. No problem. Hang on just a second. I'm going to let you talk. But it's not up to you or to me to decide how the county chooses to enforce it. Now, be that as it may, this is a repeat violation. Sometime in the past, let me see when it was. It's got to be within 5-year period.
It's been 5 years.
Well,
2019, yeah.
let me see if we're outside the 5 years, but if we are, then it was September
26.
18th of 2019, so 20, 21, 22, 23, 24, until September of 24 is when the 5 years runs. So no, I think you're within the 5-year period, which makes it a repeat violation. And the significance of that is twofold. One is it's a heightened fee schedule, and the second part of it is that it accrues immediately upon the discovery of it by the officer even though it gets adjudicated later at a hearing. So it's no joke. I mean, that's the law, and I see this with repeat violations when they occur. The county has actually, I think, asked for certainly less than $5,000, which is the maximum per violation, but what you've asked for is $8,000 for the whole period of time, 30-day period.
Correct, at $250 a day.
$250 a day.
But where do you come up with that $250? In other words, we received this is dated like February 7th, and I received this February 15th, and I immediately turned this over to my tenant. And then, as far as I know, they corrected it immediately.
Okay,
So
and-
now we are on the 20th.
And I'm going to ask them
March.
about that, too. I want to hear from your tenant,
Okay.
because, I mean, ultimately, you're going to look to them, and I understand that. All right, so do you have anything else you need to tell me, sir? Anything else that you,
Are you talking to me?
I am.
I simply, I mean, I'm the one who is on the hook for this, at the end of the day. So again, I'm not understanding why am I being threatened with fines and also liens?
It's no threat.
I mean, again, I'm asked to police this, okay? Because I had a conversation with her. She said, well, you have to police this. And, I'm a private citizen. I'm a small-time landlord.
Right.
I'm not a police officer to police this. I'm in the business of renting this property, and I happen to be a retired person. I'm 67 years old. This is my source of income. So why am I being put into this position? I'd like to, get an answer on that one from your honor. Why?
Well, and you're not being put into the position.
Well, I am.
As a landowner,
Face.
as the landowner, you are responsible for your property. Okay, it's the law, it's clear.
But I'm not the one who is perpetrating what has happened.
I know, and how
Parking
you,
the cars there.
if I fine you, how you choose to get that from your tenant is your business.
Yeah, but I mean, we are going hoops and loops again. The simple solution would be to make a phone call, which would take 10 seconds, and call the tow company and tell them to tow the car. That's simple for the county to do.
Okay, we've already discussed all of that. Let me hear from your tenant. Let me,
Hello,
you got to go right up to that microphone. And,
my name is Mark Plotnick. I actually partial owner of the dealership. First thing I'd like to mention is the violation that they say we're in violation of says no person shall have a salvage or junk or abandoned vehicle or salvage or junk on any road, street, alley, highway, or public assessment in Martin County outside of municipality with the code numbers. I feel where they're saying our car was parked illegally for a couple of days, not 30 days. Number one, I have pictures.
Got to go over to the microphone.
I'm sorry.
yeah, you got to be over.
I apologize, sir.
Into that-
I have pictures of where the cars were parked she's speaking of, and it's not in any way of the alleyway. It's not in the public way of a roadway. It's off the road. We are a small dealership trying to make it. Another point I'd like to bring is, we had the issue before with the assessment with the easement, and it was a front and it was a side. I have pictures. We have had cones put there, and the pictures that she has shows the cones where people no longer park. The front, we no longer park there. But this is county property that they don't maintain, that I have to pay $450 a month to cut it. If it's you guys' property and I'm violating, why aren't you guys maintaining the property?
Okay.
And I'm sorry to keep venting, but honestly, the man that was here earlier was the office manager, Mr. Allner. He's the one that does the emails. I don't do any emails, but he does refer the things back to me. Eddie has had problems getting responses, and I'm sorry, I just know her as Maria, the code enforcement. He's left numerous emails for her, doesn't get responses. The cars are never left there overnight.
Hang on.
Yes, sir.
Let me ask the county a couple of questions. I'm looking at the order not to repeat, which shows violations of Section 3.105, Vehicle Sales and Service, and Section 4.695, Prohibited Signs. That's Exhibit 2. And then I look at your notice of violation, Exhibit 9, and I don't see either of those. I see Section 91.33. Did I miss something?
No, Your Honor, you did not.
Okay, all right, so this is your lucky day. It doesn't happen often. What you've been charged with isn't the same violation that was charged 4.5 years ago. So it can't be a repeat violation. Let me look to see.
We really want no violations, sir.
Well, it's.
We're just trying to comply with everything.
And is this salvaged or junked or abandoned in a roadway? All those vehicles, are they operable?
Yes, sir. And they're moved at nighttime. If they're put there during the day, we
Okay.
move them at night.
All right. Had you been charged with Section 3.105,
Neither of them.
I think it would be a repeat violation and/or a violation, at least from the county standpoint, that's viable. But the charging document doesn't line up with that. So I think I'm probably going to wind up dismissing this case. Do you have anything you want to tell me as far as, this is the county attorney, so.
We would have no objection to such a ruling.
All right. I'm going to dismiss this case. And that does not mean that it can't be brought back, because it could be brought back. Now, to the extent that you do not violate the do not repeat order, you're okay. But you can't be parking vehicles out on the public right-of-way. I mean, you just can't do it.
Do you feel the vehicle she took pictures of is in a public right-of-way behind the mailbox? I have some pictures I'd like to show you if you don't mind. They're behind the mailbox. And the other thing I want to address is, why doesn't the county take care of their grass that we're not allowed to park on?
And of course, I can't tell you that at all, but look at this Exhibit 7, which is the county's overhead view.
The GSI?
Yeah, it's the GSI, and it does show some vehicles out there. I don't know exactly where that right-of-way line is.
Your Honor,
And what is your name, sir?
my name is Anovas Galarte. I'm the general manager.
Okay.
So the right-of-way, our area there where we have our business, when it rains, it really floods. I mean, very badly. So we put cones up so people won't get stuck in the mud when it does get wet. But people do come and park and come look at our cars. We don't know when they park, sometimes we don't even know they're parked there. They get in their cars, go out, look, and then leave. But I guess we could tell people not to park there, but we can't be that diligent where we see everyone do that.
All right, look at, let's look at Exhibit six. And you see the BMW that's in the front?
An employee's car.
Okay, and it's just inside the sidewalk, it looks like.
Yes, sir.
But that is still on right-of-way, because the sidewalk's not on the edge of the right-of-way.
There's really no sidewalk, it's a street, but I understand.
Well,
what
the
you're
street.
saying. Yes, sir.
Okay,
Yeah,
whatever that
We agree
pavement
with you,
is.
yes, sir.
I think the
All right.
utilities is where it shows where your right-of-way starts, right?
Often that's the case. I don't have a survey, you don't have a survey apparently, but that's typical.
We are really here to try to figure this out.
Well, you might do it starting with Exhibit 7, which is that overhead shot. And you see the nose of some of the vehicles is in the right-of-way. And there may be one or two cars parked out there, but
Those are extremely old pictures. We've moved them back 3 foot from there and have cones.
then you,
Those pictures are very old.
then you should
The
be
main
good to go.
thing, one of the main things I was curious about is another one of the pictures that had a black SUV there. That's actually my vehicle where I normally would park. I don't know what exhibit it is. Well, the white Jeep's there right now, where, you can back up, where the white Jeep was, right there, sir.
Yeah, okay, Exhibit 4.
Is that in the right-of-way as well?
That is actually behind the utility pole.
Pole and the mailboxes.
Back to the map.
Yeah, but the vehicle that's on the left of those,
Yeah, the BMW,
Right.
yeah.
That will never be there again.
yeah, that may not be. And I don't know whether the Jeep, the white vehicle in 4,
I park during the day, I leave at night.
is or isn't.
Your Honor, if I could point out, the exhibit we're looking at right now, you got a white concrete
Yeah.
driveway and a black asphalt.
So the
Now, if we
apron-
go back to Exhibit 7, you can clearly see that that delineation line is pretty much the right-of-way line. Everything outside of that is in the right-of-way.
Ah,
That's a pretty easy, bright line to figure out.
you see what
Yes, sir.
the gentleman's saying, Mr. Tui is saying, if you make sure that all of
beyond
your
the
parked
concrete
vehicles
line.
are beyond that apron, that driveway apron, then you're probably not ever going to have a problem.
Because we have
So-
sent a few emails asking to please show us where we could, and we just want to do the right thing. We're
Okay.
not trying to violate anything. And sometimes you do it without knowing, and if we know, we won't do it.
All right, and the significant part of it is that this is an expensive deal. I mean,
Believe me, my landlord's been on me for the last 30 days about this.
Okay.
The way he vented to you, I hear it on a daily basis,
all right, well,
and I
you're
appreciate what
lucky
you
from
did
that
today.
standpoint, but the paperwork didn't line up to your advantage, so, but they can refile if they ever find you in violation again. Understand
Yes, sir.
that if it's a repeat violation, so if it's something that comes between now and September 18th, it's going to be heightened fines and immediate fine from the date that it's seen. So it is, as I say, no joke. It's the real deal. So,
Do you mind if I ask the inspector to maybe give us a little time to come out and see if we're in coordination with her? We really want to get
again, that's
along.
not up to me, but I think you can call code enforcement anytime you need to make sure that if you're trying to achieve compliance, they'll help you do that.
We are trying. We've put cones up, we've had signs, and this wasn't just before this was years ago we did it.
Okay, so I'm going to dismiss the case, and you're free to go, and good luck.
God bless you.
Okay.
Thank you, Your Honor.
Okay.
I'm sorry that we
do what we do.
I really mean it.
I don't have it on me at the moment, but at the bottom of your
Violation. Thank you, sir. We really try to stay in code, and I appreciate your help today.
All right. Let's see. Okay, now where are we? Hello there. Let's see.
Should be back at the top.
Did we chase Maria off? Let me see. Has she got another case or no?
Yes.
Yeah, it's got a couple of them.
She's got a couple. You want to finish hers?
I'll take them in whatever order you want them, take them in, but,
He's gone now.
okay,
Go ahead and finish Ben.
all right, that's fine. Okay, top of the batting order it is. This is the Cotton case.
Yes, sir.
Do you swear or affirm testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, it's case number ENF 2023-080731, Donald and Bonnie Cotton.
In this case, it is actually a stipulated agreement.
Okay, great. Very good.
My name is Benjamin Norman. I have been sworn in. I'm a code compliance investigator for Martin County, and the respondents Donald E. Cotton and Bonnie D. Cotton are not present. This case concerns the property at 7003 Southwest Wisteria Terrace, Palm City, Florida, located in Martin County, Florida. This case was not generated from an anonymous complaint, and according to the official records of the property appraiser of Martin County, the property owners are Donald E. Cotton and Bonnie D. Cotton. A copy of the property appraiser's record of ownership is County's Exhibit 1. On August 28th, 2023, using property appraiser aerial photographs, I was able to determine building activity was completed at this property without required permits. So Exhibit 2 is a property appraiser aerial photo it's dated 2023. And in the photograph with the arrows, you can see there's a pool, a tennis court, and a metal structure that was built on the property. Exhibit 3 is a PA aerial photo dated from 2018, and I have the same markers in place, and you can see none of those structures are there. And Exhibit 4 is a copy of the property's permit history, which shows that the last issued permit for the property was for a gas tank that was issued in 2007.
Wow, that's some sleuthing.
Yes, sir. Thank you. I then responded to the property. However, I was unable to make contact with the owners at that time due to the property being gated. Exhibit 5 is a photograph I was able to take of the metal structure that was built on the property. This photograph was taken from the right-of-way. And the tennis court and pool cannot be seen due to their location on the property. And Exhibit 6 is a photograph showing that I left case information on the closed gate to the property.
That's what, like a courtesy notice?
Yes, sir.
Okay, go ahead.
So I received no contact from the owner, so I issued a notice of violation to Donald E. Cotton and Bonnie D. Cotton on October 4th, 2023, and this is marked as County's Exhibit 7. In the notice, I cited Section 105 of the Florida Building Code, permits when required. And in the notice of violation, the respondents were given until November 6, 2023 to correct the violation, and was informed of the need to contact Martin County Code Enforcement upon doing so. The owner did contact me after sending the notice and advised he was working on the permits required. Exhibit 8 is a copy of the permit history for the property as of October 20th, 2023. And I just wanted to show that the property owner did submit 3 separate permit applications for the structures on the property.
As of January 19th, 2024, the permit applications remained in the waiting on applicant status, so they're non-issued. A notice of hearing was then issued by certified mail to the property owners on January 19th, 2024. And this is marked as County's Exhibit 9. The owner did contact me after sending this notice and requested an extension from the hearing due to the number of conditions that needed to be corrected on all 3 permit applications to have them fully issued. I did approve his extension request. And on February 13th, 2024, an amended notice of hearing was sent to the owner by certified mail, and this is marked as County's Exhibit 10. The signed return receipt, which is Exhibit 11, was received on February 19th, 2024, indicating that the notice was delivered to the property owner on February 16th, 2024. The property owners contacted me again in reference to the permit applications and basically informed me they're having a hard time getting architects or engineers to take the job. He attempted to do the permits on his own, and he found that he could not do it. So Mr. and Mrs. Cotton decided to enter into a stipulated agreement with Martin County. They have agreed to receive issued building permits for the pool, tennis court, and metal accessory structure by August 30th, 2024, and if not in compliance by this date, agreed to the levy of a fine in the amount of $100 per day while the violation continues to exist thereafter. The respondents have also agreed to pay $350 in administrative costs, which were paid prior to today's hearing, and this concludes my testimony. And I request all the evidence, the county's exhibits, to be received into evidence.
All right, so nobody's here on behalf of the Cottons, but looking at the stipulation, I've read through it, and of course it is as recited. Note for the record that both Mr. and Mrs. Cotton have signed the stipulation, and as you have as well, Mr. Norman, on behalf of the county. And based upon that, I'm going to find that it's appropriate to enter the agreed order in this case, an order compliance on or before August 30th, 2024. Exhibit, Your Honor. Didn't I accept them into evidence?
Accept them?
I think I did. Anyway, without objection, I'm accepting into evidence the county's exhibits 1 through 12 in this case.
Oh, my God. My brain has gone numb.
Well, 1 through 11. I left 12 out because that's just, that was before I got all the stipulation paperwork. That was just showing the permits were still not issued. So that's really not relevant. I mean, we could put it in there, but.
It is actually, it is relevant. That's fine. I'm gonna accept it.
Okay.
I had already looked at it.
Okay, perfect.
Hey, you know.
Okay, thank you.
All right. Okay. Next. All right, next case is the Schmidt case. And Mr. Ambrosetti, you're going to testify if you raise your right hand. Do you swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. This is case number ENF 2023-080398, Martin County versus Schmidt. It's Glenn and Laura Schmidt are the respondents, and whatever you're ready.
Thank you, Your Honor. My name is Charles Ambrosetti, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondents, Glenn Schmidt and Laura Schmidt, are not present. This case concerns the property at 1202 Southwest Dyer Point Road, Palm City, Florida, 34990. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Glenn Schmidt and Laura Schmidt. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On August 14th, 2023, an expired permit letter was emailed to the contractor on file. A copy of the letter is marked as County's Exhibit 2. This expired permit letter was for an expired gas tank permit. On August 17th, 2023, I inspected the property and I left a door tag for an expired gas permit. At that time, I photographed the property, and the photographs accurately show what I saw then and are marked as County's Exhibits 3 and 4. Your Honor, in Exhibit 3, I'd just like to call your attention to the new driveway, which is going to come into play later in the presentation. And Exhibit 4 was the door tag that I left for the expired gas tanks.
Okay, back on Exhibit 3, you see that there's a construction, usually for plans, box
The
on the
permit
right hand.
box?
Yeah.
Yes, sir.
Do you know what that has in it?
I did not open it, no, sir.
Okay, all right, fine. Exhibit 4, I got?
Okay. Based upon the investigation, I issued a notice of violation to Glenn Schmidt and Laura Schmidt on August 28th, 2023, and that's marked as County's Exhibit 5.
Okay.
In the notice, I cited the following Martin County Code violations: Section 105.1 Florida Building Code, permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code, for an expired gas tank permit. In the notice of violation, the respondent was given until September 27, 2023, to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. On October 23, 2023, a new expired permit letter was emailed to the permit runner on file. A copy of that letter is marked as County's Exhibit 6. This expired permit letter went out for an expired permit for the driveway. Based upon the investigation, I issued an amended notice of violation to Glenn Schmidt and Laura Schmidt on November 2nd, 2023, and that's marked as County's Exhibit 7.
Okay. And
In the amended notice of violation, the respondent was given until December 4th, 2023 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. On December 20th, 2023, the gas tank permit was renewed. I then received a call from the property owner to discuss the expired driveway permit, and at his request, I provided him with an extension of time. On February 14th, 2024, I checked the permit status, and the driveway permit remained expired. Since compliance was not achieved, a notice of hearing was issued by certified mail on February 19th, 2024, and is marked as County's Exhibit 8. On February 26, 2024, the gas tank permit expired again. So on February 29th, 2024, I issued another amended notice of violation marked as County's Exhibit 9. In the notice, I cited the following Martin County Code violation: Section 105.1 Florida Building Code, permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code for expired gas tank permit and expired driveway permit. An amended notice of hearing was issued by certified mail on February 29th, 2024, and is marked as County's Exhibit 10.
Okay.
The return receipt was not received, so on March 1st, 2024, I posted the property. A photo of the posting and my affidavit of posting are marked as county's exhibits 11 and 12. Exhibit 11 is my affidavit of posting. Exhibit 12 is a photo of the posting on the door. I checked the permit status again on March 19th, 2024, and I saw that the gas tank permit had been renewed, but the cited driveway permit violation had not been corrected. A screenshot of the permit status is marked as County's Exhibit 13.
Okay.
I request that all the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondents, Glenn and Laura Schmidt, be ordered to comply with the cited provisions of the Martin County Code by April 30th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, looking out. Anybody here on behalf of Glenn or Laura Schmidt? Seeing none. Without objection, I'll accept into evidence the county's exhibits 1 through 13. Based upon that evidence and your testimony, I'll find that the violation as charged does exist on the property. Order compliance on or before April 30th, 2024, failing which a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you, Your Honor.
Thank you. Let's see. There she is. You ran away. All right, Ms. Espia, we'll take the Lynch Whittlesey case. How's that one? Can we do that one?
Sure.
Okay. All right, so this is case ENF 2023-110536. And the respondents are Margaret Lynch and Mark Whittlesey. And you've been sworn in. Whenever you're ready, let me see if I can catch up now. Okay, and it's 536. Okay, I'm there.
My name is Maria Espea, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondents, Margaret Lynch and Mark Whittlesey, they are not present. This case concerns a property at 1692 Northeast Seahorse Place in Jensen Beach, Florida, in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Margaret Lynch and Mark Whittlesey. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Got it. Good.
On November 27th, 2023, an expired permit letter was emailed to the contractor. The permit letter is marked as County's Exhibit 2. On December 1st, 2023, I went to the property and left an expired door tag for contact. The door tag is County's Exhibit number 3. And if I zoom in, it was for windows.
Okay.
Based upon the investigation, I issued a notice of violation to the owners on January 29th, 2024, marked as County's Exhibit number 4. In the notice, I cited the following Martin County Code violation: Section 105.1, permits when required, incorporated by Section 21.1, General Ordinances, Martin County Code. In the notice of violation, the respondent was given until February 12, 2024 to correct the violation, and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail and regular mail on March 1st, 2024, and is marked as County's Exhibit number 5. The return receipt was not returned, therefore, on March 6, 2024, I posted the property and the Martin County Admin Building. The affidavit of posting is marked as County's Exhibit Number 6.
Okay.
I also emailed the contractor on March 6, 2024, to resolve the violation. The email to the contractor is marked as County's Exhibit Number 7.
Okay.
No call or letter from the property owner was received within the time allowed. Therefore, on March 19th, 2024, I checked the permit status, and it still shows that the permit is expired. The permit status is marked as County's Exhibit Number 8. This shows that the work was actually done. One of our inspectors went out and they failed the inspection as well, and up here, the status shows it expired. I request that all of the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondents be ordered to comply with the cited provisions of the Martin County Code by April 30th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violations continue thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing.
All right. Have you had any contact with Ms. Lynch or Mr. Whittlesey?
No.
Okay. All right. Let me just say something. All right, so let's see, well, okay. I mean, you sent them the notice of violation in January, the end of January. And you posted. Okay. And they just never contacted you?
Correct.
Sure. Okay, good. Well, looking out, I don't see anybody here. Anybody here on behalf of Margaret Lynch or Mark Whittlesey? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 8 in this case. Based upon that evidence and your testimony, I'll find that violation as charged does exist on the property and order compliance on or before April 30th, 2024, failing which a fine in the amount of $100 per day will accrue, and further awarding cost in the amount of $575 to be paid to the county at the conclusion of this hearing. And it is so ordered. Okay. The next one is Lee Nee. It's ENF 2023-110605, and the respondent is Lee Nee, L-E, capital N-G-H-I. And whenever you're ready.
My name is Maria Espea, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Nee Lee, is not present. This case concerns a property at 1156 Northeast Terrace Way in Jensen Beach, Florida, in Martin County. The case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the owner is Nee Lee.
It's the other way. Got it. I was saying in Lee Nee, but it's Nee Lee.
A copy of the property appraiser's record of ownership is County's Exhibit 1.
Got it. Okay, go ahead.
On November 29th, 2023, I inspected the property. At that time, I've seen trash and an unpermitted fence. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibit 2. This is a new fence that has no permit. Here's trash, along with trash throughout the yard.
Okay. How did you get that shot?
So the neighbor is building a brand-new home that's two-story, and I was able to go to the second floor with his permission.
Very good.
On October 18th, 2023, I closed the case for the same violations under case number ENF 2023-070001. The prior case information is county's exhibits 3 and 4. This is exhibit 3 from the prior case. This fence was also unpermitted, and he also had trash throughout the yard at that time.
Okay.
Exhibit number 4 is just the notice of violation from the prior case. So based upon the investigation, I issued a notice of violation to the owner on December 4th, 2024, marked as County's Exhibit 5. In the notice, I cited the following Martin County Code violation: Section 105.1, permits when required incorporated by Section 21.1, General Ordinances, Martin County Code. Section 67.201.b, nuisance declared trash, etc., General Ordinances, Martin County Code. In the notice of violation, the respondent was given until January 2nd to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. I did a follow-up inspection on February 9th, 2024, and seen a new unpermitted structure existed on the property. The follow-up photos are marked as County's Exhibits 6 and 7. Here's more trash, but this is a new structure that was unpermitted as well. And number 7 is just a different angle of some of the trash that was there. You can see slightly in the corner that the fence was still there as well. On February 14th, an amended notice of violation went out to the property owner to include the new unpermitted structure under the same code of 105.1 and was given a new compliance date of March 15, 2024. The amended notice of violation is marked as County's Exhibit 8. And here's where I added it.
Okay.
Okay. I also included with this amended notice of violation some photos. The photos are marked as County's Exhibit number 9. So I asked them to please call me. The new fence requires a permit. And I circled the trash and what was unpermitted as well. A notice of hearing was issued by certified mail and regular mail on February 14, 2024, and is marked as County's Exhibit number 10.
I'm back looking at Exhibit 9. I think that's a terrific idea. No, I really do. I mean, I think it's a really good way to show respondents what they violated. Okay, go ahead. Exhibit 10, sorry.
No, that's fine. So the notice of hearing is at County's Exhibit number 10, which was sent out February 14, 2024. The return receipt was not returned, therefore I posted the Martin County Admin Building and the property on March 6, 2024. The affidavit of posting is County's Exhibit 11. No call or letter from the property owner was received within the time allowed. Therefore, I went again on February 19, 2024, and saw that the cited violations had not been corrected. At that time, I photographed the property. The photographs accurately show what I saw then, and they're marked as County's Exhibits 12 and 13. 12 is from a distance. This is the fence.
Okay.
And number 13, you still have some items scattered and the unpermitted structure in the back as well. I also checked for permits and found none applied for. The permit history is marked as County's Exhibit 14. These are the last 3 permits that were applied for, was roofs, and an AC change-out. I requested all of the county's exhibits be received into evidence. Based upon the testimony and evidence, I requested the respondent be ordered to comply with the cited provisions of the Martin County Code by April 30th, 2024. If not in compliance by then, be required to pay a fine in the amount of $100 per violation per day for every day the violations continue thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
All right. Anybody here on behalf of Nee Lee? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 14 in this case, based upon that evidence in your testimony. I will order compliance on or before April 30th, 2024, failing which a fine in the amount of $100 per violation per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. Let me just sign this one. Okay, so ordered. Let's see, you've got one more.
Yes.
Driftwood Industrial LLC. It's ENF 2023-120414, and the respondent is Driftwood Industrial LLC. Okay. Okay, whenever you're ready.
My name is Maria Espea, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Driftwood Industrial LLC, is not present. This case concerns a property at 657 Northeast Dixie Highway in Jensen Beach, Florida, in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Driftwood Industrial LLC. A copy of the property appraiser's record of ownership is County's Exhibit 1. An expired permit letter for a metal building was emailed to the contractor on December 18, 2023. The email is County's Exhibit Number 2. On January 4th, 2024, I left an expired door tag. The door tag visit is County's Exhibit Number 3.
And I'm sorry, where did you leave the door tag?
In the front of the business, in their door.
This is the Driftwood Industrial business?
Correct.
Okay, all right.
Based upon the investigation, I issued a notice of violation to Driftwood Industrial LLC on February 1st, 2024, marked as County's Exhibits Number 4. In the notice, I cited the following Martin County Code violation: Section 105.1, permits when required, incorporated by Section 21.1, General Ordinances, Martin County Code. In the notice of violation, the respondent was given until February 14th, 2024, to correct the violation, and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail and regular mail March 1st, 2024, and is marked as County's Exhibit Number 5. The return receipt was not returned, therefore, on March 6, 2024, I posted the Martin County Admin Building and the property. The affidavit of posting is marked as County's Exhibit Number 6. When I was posting the property, I explained to the manager on site the issue and how to correct it. That same afternoon, someone who represented the property called me, and I explained to them how to correct it as well. I asked them to make contact with the assistant building official. The next day, I emailed the assistant building official asking if they made any kind of contact with him, and they did not. The email is County's Exhibit Number 7. So this is the email where I asked Scott Bruin if they had made any contact with him, and they did not. On March 19, 2024, I checked the permit status, and it showed that the permit remained expired. The permit status is County's Exhibit Number 8. The building is there. As you can see, it passed some of the inspections, and there's still some pending, but it's still expired. I requested all of the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent be ordered to comply with the cited provisions of the Martin County Code by April 30th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violations continue thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. Anybody here on behalf of Driftwood Industrial LLC? Looking out, I see no one. And so without objection, I'll accept into evidence the county's exhibits 1 through 8 in this case. Based upon that evidence and your testimony, I'll find that violation as charged does exist on the property and order compliance on or before April 30th, 2024, which I guess in this case is renewing the permit, having an open permit.
Correct, and I
Yeah.
believe the order might say, and passing a final inspection, I'm not sure.
Let me look. Yeah, proceed and pass the final inspection, which should be fine because it's after the fact kind of anyway. All right.
Thank you.
So I am going to order compliance on or before April 30th, 2024. Failing which, a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
Okay. Thank you. Let's see, where are we? Ms. Bush.
Yes, sir.
All right. You've got the Carroll case. We'll take that one.
Okay, we can do that one first.
No, you've got one before that. It's the
Prince Kelly Revocable Trust.
Prince Kelly Revocable Trust. Okay.
Yes, sir.
All right, so we'll take that one. It's case number ENF 2023-080058. And it's Martin County versus Prince E. Kelly Revocable Trust, with Prince E. Kelly as trustee, Edward Dean Gaithers, Elmer Dean Gaithers, Frederick Gaithers, and Sandra Allen Kelly. Okay, so let me catch up. Zero, 5, 8. Got it, all set. If you raise your right hand, you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
All right, whenever you're ready.
My name is Tamika Bush, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Prince E. Kelly Revocable Trust, Kelly Prince E. Trustee, Edward Dean Gathers, Elmer Dean Gathers, Frederick Gathers, and Sandra Allen Kelly is not present. This case concerns the property at 8678 Southeast Anthony Way in Hobe Sound, Florida 33455, and Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Prince E. Kelly Revocable Trust, Kelly Prince E. Trustee, Edward Dean Gathers, Elmer Dean Gathers, Frederick Gathers, and Sandra Allen Kelly. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay, I'm just looking at the quitclaim deed that's attached to it,
Yes, sir.
and it looks to me like if this is the last deed, which is September 19th, 2023, it's just the grantee is Prince E. Kelly, trustee of the Prince E. Kelly Revocable Trust. So maybe some of those other folks.
Your Honor, just for clarification, we believe there's some sort of litigation involving this. I believe Ms. Bush said that she had spoke to someone who was acting as a mediator in a dispute. So I had them put all of the names in case, because if that deed is so close in date to now, it may wind up being set aside as a result of that.
All right. Okay. Good enough. Everybody gets notice?
Yes, sir.
That's fine. Sorry to interrupt you. You're looking at Exhibit 2, I think, which was the photo. That's where I stopped you.
On August 10th, 2023, I inspected the property, and at that time, I observed the property was abandoned with no windows, garbage, trash, and debris. At that time, I photographed the property. The photographs accurately shows what I saw then and is marked as County's Exhibits 2 and 3 on September 18th, 2023.
Okay.
At that time, they had added new windows. Based upon the investigation, I issued a notice of violation to Prince E. Kelly Revocable Trust, Kelly Prince E. Trustee on October 11, 2023, and had given until November 10th, 2023, to comply with the notice of violation, which is marked as County's Exhibit 4. An amended notice of violation was sent on December 4th, 2023, adding the additional owner, Kelly Prince Allen, and given additional time to comply, and is marked as County's Exhibit 5.
Okay.
In the notice, I cited the following Martin County Code violations: Sections 105.1, permits when required, incorporated by Sections 21.1 General Ordinances of Martin County Code, Sections 21.110, General Exterior Structure General Ordinances of Martin County Code, Section 67.201, Trash Nuisance Declared, General Ordinances of Martin County Code, Sections 21.76, Vacant Abandoned Structures, General Ordinances of Martin County Code. And in the notice of violation, a respondent was given until January 12th, 2023 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. An amended notice of hearing was issued by certified mail on March 7, 2024, and is also marked as County's Exhibit 6.
Okay.
The return receipt was not received, and the property and administration building was posted in an affidavit of posting. It's marked as County's Exhibit 7. There were no additional calls or letters from the property owner. However, I did receive an additional email from Barbara M. Caldwell, Esquire, and I sent her a copy of the amended notice of violation. I also sent her an email with the amended notice of hearing for today's hearing.
Okay, and do we know who she represents?
No, sir.
One of the respondents?
I'm not quite sure, sir.
Okay, all right. Not a problem.
Therefore, I went to the property again on March 20th, 2024, and saw that the cited violations had not been corrected. At that time, I photographed the property. The photographs accurately show what I saw then, and it's marked as County's Exhibits 8 through 10. Exhibit 10 being the screenshot showing that no permit was applied for the windows. And at this time, I request that all the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent, Prince E. Kelly Revocable Trust, Kelly Prince E. Revocable Trust and Trustee, Edward Dean Gathers, Elma Dean Gathers, Frederick Gathers, Sandra Allen Kelly, be ordered to comply with the cited provisions of Martin County Code by April 30th, 2024, and if not in compliance by then, be required to pay a fine and the amount of $100 every day for the violation, for each violation for every violation every day that it continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that county be reimbursed this amount at the conclusion of today's hearing.
Okay, good, thank you. So anybody here on behalf of Prince E. Kelly Revocable Trust or any of the Gaithers, Edward Dean Gaithers, Elmer Dean Gaithers, Frederick Gaithers, or Sandra Allen Kelly? Looking out, seeing no one. Without objection, I'll accept into evidence the county's exhibits 1 through 10 in this case. Based upon the evidence and your testimony, I'll find that violations as charged do exist on the property, 4 violations. Based upon that finding, I will order compliance on or before April 30th, 2024, failing which a fine in the amount of $100 per violation per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you, Special Magistrate.
Yes, ma'am, thank you. All right. Let's see, we've got the Carroll case now.
Yes, sir.
This is case number ENF 2023-100485-01, Brandon and Caroline Carroll, Carroll. Okay, and
The respondent has entered into a stipulation of agreement. My name is Tamika Bush, and I have been sworn in. I am a co-compliance investigator for Martin County. This case concerns the property at 8998 Southeast Colony Street in Hobe Sound, Florida, 33455 in Martin County, Florida. The respondent, Brandon J. Carroll, and Caroline H. Carroll, is not present. This case was not generated from an anonymous complaint, and according to the official records of the property appraisal of Martin County, the property owner is Brandon J. Carroll and Caroline H. Carroll. Caroline H. Carroll, yes. A copy of the property appraisal record of ownership is County's Exhibit 1.
okay.
On October 24th, 2023, I inspected the property, and at that time, I observed a wooden structure in the rear and left a door hanger. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibits 2 through 3. That's the door tag.
Okay.
This is the structure that was built in the rear.
Okay, do we know what it is?
No, sir, not quite.
Fine, it's a structure.
Based upon the investigation, I issued a notice of violation to Brandon J. Carroll and Caroline H. Carroll on November 8th, 2023, marked as County's Exhibit 4. And then the notice, I cited the following Martin County Code violation. Section 105.1 FBC permits, when required, incorporated by Sections 21.1 General Ordinances of Martin County Code.
Okay. Before you go too much further, you got two Exhibit 4s. One of them is just a photo of the property.
Yes, it should have been excluded.
All right, so I'm
It's just a
gonna,
photo of the front. We can add or not.
I'm gonna just discard that. That's not
Okay.
in evidence, okay, or won't be in evidence. So we'll just go with your 1, 2, 3, 4 being the notice of violation.
Yes, sir.
All right, go ahead. I think you were up to the amended notice?
Yes, sir.
Go ahead.
Well, the notice. In the,
Sorry, it's okay, just start anywhere.
I issued an amended notice of violation on December 14, 2023, granting additional time given until February 12, 2024, and that is marked as County's Exhibit 5, the amended notice of violation.
Okay.
Compliance was not achieved, and the notice of hearing was issued by certified mail on February 21st, 2024, and is marked as County's Exhibit 6. The return receipt was not received, and the property in County's Administration Building was posted on March 8th, 2024, and is marked as County's Exhibit 7. Therefore, I went to the property again on March 19, 2024, and saw that the cited violations had not been corrected, and at that time, I photographed the property. The photograph accurately shows what I saw then, and is marked as County's Exhibit 8 and 9. And that's the structure that still exists.
All right.
And Exhibit 9 being a screenshot showing that the permit had not been applied for yet.
Got it.
I made contact with the respondent on March 19, 2024, whereas the owner signed a stipulation agreement, all fees has been paid. I request that all the county's exhibits be received into evidence, and based on the testimony and evidence, I request that the respondent, Brendan J. Carroll, Caroline H. Carroll, be ordered to comply with the agreed stipulation by, it is not March 29th.
I'll tell you in a sec. Let me-
I gave him additional time. Yeah.
It says June 28th, 2024.
On a stipulation agreement, yes, sir.
Yep. Is that correct?
Yes, sir.
Okay, good.
They're waiting for engineering drawings and some other things
All right.
as well. And if not in compliance by the required time, to pay a fine in the amount of $100 per day for every day the violation continues thereafter.
Yep, 100. And 350 is paid. The 350?
Yes,
It was paid.
yes, sir.
Okay, good. All right, so without objection, I'm going to accept into evidence the county's exhibits 1 through 9 in this case, based upon the evidence and the stipulation in your testimony. I'm going to find that it is appropriate to enter the agreed order. Note for the record that both Brandon J. Carroll and Caroline H. Carroll have signed the stipulation. And Ms. Bush, I'm going to get you to sign it too,
Yes, sir.
if we can. Thank you. So that leads to being able to just do a little bit of a commercial and note that the costs for these hearings are $575, but if you enter into a stipulation as a respondent, the county normally lowers that to $350. So you can save yourself some money if you find yourself in violation and just need some time to comply and conform. So, thank you. All right. So I'm looking at the stipulation Ms. Bush has now signed on behalf of the county. I'm going to go ahead and execute the agreed order in this case and order compliance as stated. So,
Thank you,
good.
Special
Thank you. Thank you, thank you. All right. Oh, you got one, do you have one more? Is the Stolting case on you? Is that coming off?
Okay.
Stolting?
They were here this morning, sir.
Yes? Go ahead and sit for a minute. And just tell me what it is.
Sorry. They did appear this morning, sir.
Yes?
They had applied for a permit for their property. However, they were still in the decision-making as whether or not to apply for a variance for a structure indoor carport. However, they did sit through part of this morning's hearing,
Yes.
and it was beginning to become very lengthy, and they spoke with zoning as well as Ms. Bradley, and we had agreed that if they applied for the variance, they would get an additional 30 days.
Okay,
So they went over to talk with zoning, so we removed them from the agenda.
all right. So you basically have extended that
Yes, sir.
30 days. Okay, so this may or may not appear on a
Yes, sir.
future. Okay.
Thank you, Special Magistrate.
Yes, ma'am. Thank you. All right, let's see. Ms. Bradley.
Yes, sir.
All right. Okay. Trinidad and Three Bagels
Yes, sir.
LLC? Is that what you got that's in that?
Well, it's under Foxgrove up there
Where's
for you.
Foxgrove? Oh, the case is,
The case is
Now
under
titled-
Trinidad, but the order is under Foxgrove.
oh, I can hardly wait to hear this one. They're always the most interesting. This is case number 07
Yes, sir.
00162 687. Trinidad and Three Bagels LLC. Let me find that on the list here. 07 case. That almost predates me. Not quite. Not quite. All right, whenever you're ready. Yeah, and I got to swear you in. Do you swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
How is it that it's 1:51 and you haven't been sworn in yet?
I know. It's been a day.
It's been a day. All right, let's go.
My name is Rachel Spradley, and I've been sworn in. This case concerns the property located at 6155 Southwest Layton Farm Avenue in Palm City in Martin County, Florida. On October 25th, 2010, a stipulation and agreed final order was issued by the Code Enforcement Magistrate to Foxgrove Farms LLC for Section 110.1.c.1, Development Orders, Land Development Regulation, Martin County Code, Section 10.11.a, Requirements for Developments and Plats, Land Development Regulations, Martin County Code, and Section 105.1, Florida Building Code, required as incorporated by Section 21.1, General Ordinances, Martin County Code. Compliance was required by January 25th, 2011. On February 13th, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $1,448,000 plus costs in the amount of $2,902.50. The property owners of 2655 Southwest Stony Brook Way, Hurricane Real Estate Holdings, have offered to pay $45,000, which represents 5% of the property value for the property located at 6155 Southwest Layton Farm Avenue. The property owners of 2655 Southwest Stony Brook Way have offered to pay the 5% of the fine for this lien in order to receive a partial release of the lien that has crossed over the property lines. So that concludes my testimony for this one. So this one was a little convoluted. So originally, Foxgrove owned not only the Layton Farms property, which is the property that we have the fine on, they owned the Stony Brook property at the time also. So their lien crossed the two properties with the way ours is set up, because it's set up to cross any real property.
Okay.
So the owners that, or the people that are purchasing Stony Brook are offering to pay 5% of the total $90,000, which would be what the 10% of the total fine would be, because we would go off the property value for this one,
And so that it releases them.
so that it'll release them. So it's gonna leave the other 5% of the total fine still left on Layton Farms property, which is who own, Trinidad and Three Bagels is who owns it now. Foxgrove no longer owns it.
And they don't want to participate?
This came from our attorney's office, so
Oh, okay.
Sebastian's only had contact with the people that are buying Stony Brook.
Okay. Works for me.
So that's where I'm at this point.
All right. Let's see, explain this one to the.
Yeah, I know.
Commission. All right, so I've got in front of me a stipulation signed by Michael J. Kungas, Sr., as manager for Hurricane Real Estate Holdings. And how do they fit into it?
They are who is right now.
They are Foxgrove Farms?
No. Foxgrove has no standing in either of these properties anymore.
Okay.
So Michael, if I'm not mistaken, is the gentleman who is purchasing the property.
And it's just all tied back to
The old
property
order.
description?
Yes, sir.
The new order. Okay, all right. Well, all right. Let's see. Partial release of lien. Okay. All right, so I'm going to find, without objection, I'm going to accept into evidence the
You are.
county's exhibits 1 through 4
You want me to put them on the record first?
Yes, please, although I've read them all.
I know. Exhibit 1 is the property appraiser showing that Trinidad and Three Bagels LLC is the owner of the property on Layton Farm. Exhibit 2 is the recorded stipulation agreement that was put into place for that property. And
Hey, look, good.
you were the signature, yeah, I was gonna say, you were the magistrate at that time. And Exhibit 3 is the affidavit of compliance with accrued fines that we put into place. And Exhibit 4 is the reduction request that was received by Sebastian up in the legal department.
Got it. Okay, so again, without objection, I'm going to accept into evidence the county's exhibits 1 through 4 in this case. Based upon that evidence and your testimony, I'm going to find that it is appropriate to recommend to the county commission a reduction in fine from the 1.4 million to $45,000, and as half of the amount that would normally be accepted, and grant a partial release of lien to the owners. In this case, it's Michael J. Kunga Sr., manager for Hurricane Real Estate Holdings. And I'm gonna, so ordered, and today is March 20th. Okay. All right, that was that. And the Marmon case, John B. Marmon, it's ENF 2020-020082-01. And this is also a fine reduction stipulation.
Yes, sir.
And what do we got there?
Okay. My name is Rachel Spradley, and I've been sworn in. This case concerns the property that has no address. It's vacant land out in Indiantown.
Okay.
So on September 16th, 2020, an order finding violation was issued by the code enforcement magistrate to John B. Marmon for Section 105.1 permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code. Compliance was required by October 30th of 2020. On February 15th, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $120,100 plus costs in the amount of $575. Nora Ochoa is the current owner of the property pursuant to a warranty deed recorded in official record books 3160, page 983, Martin County, Florida, public records. The respondent has no remaining interest in the property. Staff has determined that a lien reduction is warranted. The current owners were not responsible for the violation. However, they brought the property into compliance and have offered to pay $12,067.50 to resolve the outstanding fines which have accrued. And that concludes my testimony for this one.
Okay.
And Exhibit 1 is the property appraiser
Yeah.
showing the new owner's information. Exhibit 2 is the original order that was put into place on the property. Exhibit 3 is the affidavit of compliance with fines.
Okay.
And Exhibit 4 is the reduction request that came from Nora.
All right, let's see, it was 120. All right, so 12,000.
The reduction's actually for $12,067.50.
right, 12,067.50. And, okay, note for the record that it is signed by Nora Ochoa. All right, fine. Without objection, I'll accept into evidence the county's exhibits 1 through 4 in this case, based upon the evidence and the fine reduction stipulation signed by Nora Ochoa and by Rachel Spradley on behalf of the county. I'll find that it is appropriate to recommend a reduction in the fine from $120,675 to $12,067.50. And so ordered. Okay. All right, and let's see, we got one more. Melton.
Yes, sir.
Melton Management. Also a fine reduction stipulation, and
Yes, sir.
it is case number ENF 2023-020483. And whenever you're ready.
My name is Rachel Spradley, and I have been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 3546 Northwest Federal Highway, Jensen Beach in Martin County, Florida. On June 21st, 2023, an order finding violation was issued by the Code Enforcement Magistrate to Melton Management Incorporated for Section 105.1 FPC permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code. Compliance was required by July 31st, 2023. On January 23rd, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $17,000 plus cost in the amount of $575. Staff has determined that a lien reduction is warranted. The respondents were responsible for the violation, and they brought the property into compliance and have offered to pay $1,757.50 to resolve the outstanding fines which have accrued. That concludes my testimony for this one.
All right, go ahead and just run us through.
Okay. Exhibit 1 is the property appraiser showing that Melton Management is the owner of the property. Exhibit 2 is the original recorded order finding violation on the property. Exhibit 3 is the affidavit of compliance with accrued fines. And then Exhibit 4 was the request for the reduction that
I didn't
came.
look at that yet. Let me just see that. All right, so this is a McDonald's?
Yes, sir.
All right. Because I note that Antoine Smith, Construction Director of the McDonald's Corporation, has signed on behalf of the respondents. And,
I do have his power of attorney to sign, if you would like to see.
okay, yeah, and it's talked about in that email and chain, but I didn't see it, so we may want to put that into the record. Okay. Okay. All right. let's enter the power of attorney as exhibit number 5. All right, so without objection, I'll accept into evidence the county's exhibits 1 through 5 in this case. And based upon that evidence, I find that it is appropriate to agree to a recommended order reducing a fine from $17,575 to $1,757.50. And note for the record that Antoine Smith has executed on behalf of the McDonald's Corporation, and Ms. Bradley, you have on behalf of the county. And it is so ordered. Okay, and let me go back. I thought I saw one other case, and maybe it's been removed. The Clifford Johnson estate?
We took that one off.
It is removed?
Yes, sir.
Okay. And what about Michael Richmond?
He was also removed.
Okay. I was working off of my own docket, not yours, so. That looks like it, right? Okay, good.
The only thing we have left is the minutes up there.
Yes, and there are 3 sets of minutes, and I've reviewed them all. They are the minutes for, well, let me just, make sure I write them down. Minutes for March 13th, 2024, and I'm going to just quickly look at those just to make sure, because yeah. Okay, yeah, that's fine. February 21st, 2024, and January 17th, 2024. All right, and I have approved all of them now, so I'm going to go ahead and sign them. Come on. Good. All right, so our next hearing is not in April. Oh, are you having a hearing in April? You're not, okay. So our next hearing will be May. I'll look at that and tell you in a second. It should be May 15th here in Chambers, right? Okay, very good. We'll see you then. Thank you.
Thank you.